4 main grounds indicated in paragraphs 24 to 26. My lord, the first one being that of express my lord, I have indicated those grounds at the end of page 5, but and the point I have already argued is the first point at page 5 is with regard to addition and subtraction not possible and suo motu cognizance can be taken by your lordship. My lord, the division bench judgment which my learned friend has relied on, the Lord Griha Nirman judgment of this honorable court, even in that the division bench refers to in at paragraph 5 and 6 refers to these points. My lord, with regard to the second paragraph and the second point, that there has to be an express or implied agreement, it has to be for a common purpose, there has to be shared profits and equal members voice in controlling the said project. My lord, apart from the first ground, the necessary elements are not fulfilled in this contract, because my lord, the common purpose is missing insofar as the purpose of the landowner and the purpose of the petitioners are completely different. The landowner uses it for residential purpose and is looking for a his residential accommodation to be reconstructed, whereas the developer, the petitioner, is trying to do it for his own commercial gains or for his own financial benefit. My lord, so the common purpose is different. Insofar as the third point of shared profit and losses are concerned, my lord, the landlord is restricted insofar as the allotment of 50% identified in the agreement. And my lord, this 50% is not based on any other constraints, but what the law, the floor area ratio under municipal laws, whatever it permits, I would be entitled to 50% of that. It is not a matter of risks and costs involved for me. It is not a matter of my shared profit or losses, and I am not sharing any of the profit and losses. I am only entitled to 50% of the constructed floor area ratio. Now, my lord, the any profit or loss is directly attributable to the developer. So this is not a co-venture at all. And my lord, the fourth point is with regard to equal voice in controlling the project. My lord will see from the agreement itself, I am only to provide the originals. I am only to comply, execute power of attorney. I may assist him while he is negotiating with the tenants, but it is all of this is his liability. Any penalty, any payments are his liability, which are to be
Power of attorney cannot be an agency.
Power of attorney can be an agency. I will come to that. But with regard to the agency point, I will come. But my lord, here I am not to go with him. I am providing him that power of attorney to act as an owner, because certain permissions and grants has to be taken out by the owner. I am not required to do it, which shows that there is no equal voice. He obtains all the licenses, he acts and prepares the project. I am only to provide him that authority for the purpose of making the necessary applications and supply him with the original deeds and documents. Now, my lord, so there is the effective part is I do not have any voice or control over the project. It is not my decision that it should be a 3-storied or a 4-storied or part commercial or residential. It is his decision to construct. From the construction, I may get certain benefits by providing my share of the consideration in respect of my rights on the land. I am not participating in the project in any manner, save and except one clause which has been shown where there is a joint decision of deciding the tax. Apart from that, there is no clause which my learned friend has shown where there is any joint decision involved. All the points are that I will be providing. I will be in negotiations with tenants. It will be done with him. But it is his prerogative on the basis of which the tenants are to be vacated. That is also borne out from the letters which has been exchanged between the parties. I will take my lord through that as well. And therefore, my lord, there is no controlling voice of the landowners in the project as well. My lord, one more important statement in the particular judgment at paragraph 26 of Fakir Chand Gulati is the fact that both the developer and the landlord would be a co-venturer or a joint venturer, and they will be acting as both principal and agent of each other. It cannot be that the landowner is the principal and the developer is a mere agent of the particular landowner. My lord, I will kindly just one line, my lord, from the judgment which I've already placed before my lord. If my lord comes to the page 32 of the report, I can read out to my lord as well. Page 362 of the report, my lord. Last line of paragraph 26, my lord. Page 362 of the report. It starts at 361, paragraph 26. Only the last line I wish to place.
Yes.
The requirement. The requirement of each joint venturer being the principal as well as the agent of the other party.
Where from you
My lord,
reading?
the first line sentence starting with the requirement of page 362, my lord.
362.
Yes, my lord. 362.
Hmm.
The very first line, my lord, it's venturer. Therefore, the sentence starting, the requirement of a joint venturer being the principal as well as agent of the other party is also significantly absent. We are therefore of the view that such agreement is not a joint venture as understood in law. So, my lord, it also indicates that there is a requirement for a joint venturers to be both principal and agent of one another. Merely being an agent, the developer being an agent of the principal, completely demolishes, by as he has cited judgments to that effect, completely demolishes his case as a co-venturer. If in a development agreement, my
No, kindly read.
lord,
The requirement of each joint venture
venturer
being the
the
principal as
is
well as the agent of the other party is the significant,
significantly
and
absent.
that it is not the case of the plaintiff herein. He is telling that in terms of the power of attorney, you are the agent, he is the agent,
He's the agent.
and in terms of the power of attorney, it's a joint venture. As per the joint venture, the agreement, the work is to be executed.
My
So
lord,
how you can say it is not? It is absence.
my lord, in any
Whether
event,
the court has to decide whether this is only two questions is raised, whether this is the joint venture or whether it is the agency.
agency,
So this is not the question you have raised.
my lord.
With regard what you are not are now arguing a new argument you have placed, it is not your case made out in the plain your of
In the petition, no, my lord.
then
My lord, my learned friend has relied on the judgment of Ashok Kumar Jaiswal.
correct,
He has referred to paragraph 32 of that judgment,
correct.
which is a full bench judgment of this honorable court, where a development agreement has been identified as an agreement for agency, and the developer is an agent of the principal.
Correct.
If he relies on the particular judgment to show that it would be an agreement for agency, and the developer would be the agent of the principal, then automatically, my lord, the essence, the requirement of a developer and a landlord being principal as well as agent of one another, which is indicated in the test, one of the tests of the Fakir Chand Gulati judgment of the Supreme Court, is absent. Because the moment he says that I am only an agent, as per 32, paragraph 32 says that the developer is an agent.
Which paragraph 32?
Paragraph 32 of Ashok Kumar Jaiswal judgment, my lord, which my learned friend has relied on. In that judgment, it is his argument that by being the agent,
Yes, relied upon paragraph 44.
44, I'm sorry.
'58 and 63.
Larger, rather larger. My lord, his argument on the basis of this judgment was that the developer would be the agent. The developer would be the agent of the principal, of the landowner, which is why by execution of the power of attorney he becomes the agent, and therefore he is actually acting in for the development agreement would also be an agreement for agency. If he simpliciter keeps himself as the agent of the landowner, then automatically he does not become, it is not a principal as well as agent basis for both of them. It is a simpliciter fact that the developer remains an agent of the landowner.
No. See,
My lord.
development agreement executed.
My lord.
Correct.
Yes, my lord.
And the owner said, yes, you developed it. Whatever the tenancy portion, this portion you develop it, give it to me. I will hand over to the tenant and I will let out the tenant. And remaining portion, you make construction, you enjoy it.
My lord.
Correct. This is
My
one
lord.
aspect. Second, the power of attorney, you do this, and I am not in a position to go to the office and to act on my behalf and purchase the material, whatever it is. So why you are telling that both cannot be?
My lord. My lord, he in this particular agreement, there is no obligation or liability
That is
on the
different
yes, my
thing.
lord.
That is different thing.
That is what
If
I'm
it
trying to
is there
indicate.
or not.
My lord, if I may please 58 of that judgment, which my learned friend has relied on and argued, understood in the sense that the development agreement has been in such context the agency created by a power of attorney executed by the owner in favor of the developer may be seen to recognize an interest of the developer in the property which forms the subject matter of the agency. But to stop here, in answering the second question in the reference would be abject failure to recognize the implication of the question. If the limited answer thus far given in response to the second question implies that such agency can never be annulled, it would be it would make a mockery of the legal position. My lord. So, my lord, the main specification is that the agreement his argument was that insofar as this power execution of power of attorney, there is an agreement for agency which is included. My lord, if the agency is to be seen by the of the developer, that the developer is acting as an agent, then automatically the developer, it is not his case that it is a principal to principal transaction, but it is in respect of the particular property. I am an agency carrying out the work on your behalf. My lord, for a joint venture, the basic what the particular judgment indicates, for a joint venture both of them have to be principal who are acting as agent of one another. It is not his case that he is acting as a principal in respect of certain aspects and I am acting
How
as a
in the
principal.
agreement both can be a principal?
Well, it may be an agreement where two principals are agreeing to execute a particular
That is
work.
different thing. Here is
And
not
that
the
is the
case.
joint venture, my lord.
Here is not that case. Here is not the case. Both are the principal. Here
Sir,
what?
if today I had agreed with my learned friend to construct a building where he has the land, I will make the investment, both of us will go obtain a permission and construct it together. Whatever we make, benefit or profit from the particular construction or loss will be shared between him and me. That is a principal to principal transaction. But where agree enter into an agreement with him that it will be my investment over his land, and from whatever comes, or rather I will do the entire thing and he will be a sleeping partner, that is not a of the particular agreement, that is not a a co-venturer or a joint venturer in that aspect. He will only get whatever his share is as a consideration for giving up his land, whereas I am the one who is carrying out the construction, executing. I am the main principal in respect of the entire construction work. My learned friend's case was that the land, there is an agreement for agency where he is an agent executing work on my behalf in terms of this particular judgment. He does not indicate that he is the principal, but he indicates himself to be the agent carrying out my work, which was the joint venture. Mallet, in that aspect, I'm only trying to place that for that argument, it would fail because if he is an agent of the landowner, then it is not a joint venture or a co-venturer agreement. It is merely a principal agent transaction, not a principal to principal transaction or vice versa, where he is the principal, I am the agent, or I am the principal, he is the agent. It is not a transaction of that particular nature. So that is my submission with regard to the particular agreement for agency that he has come forward. The point of agreement for agency would also fail, that in case if he says that it is my, he is acting as my agent, then the principal's right in respect of the property is that of a residential right. The principal also, me as the principal, would also intend to use it for resident. I have been, and I intend to use it for my residential use. So therefore my agent, if I, it is for my residential use, it is not a commercial transaction, it is not used for trade and commerce by me, and my agent would automatically not be able to bring it under the fold of a commercial dispute. So on both scores, if he comes up across today and says, I am an agent and there is an agreement for agency, or I am acting as your agent, at that point on both scores it will not be a commercial dispute. So that is my submission, that one, as a joint venturer also it cannot be a commercial dispute. As a principal and you are an agent, it cannot be a joint venture, because my use is for residential purpose.
Okay.
My lord. Thereafter, uh, my lord, I have also indicated that the relevant clauses, that I have no controlling voice in the particular project. I have already placed this. My lord, even all penalties.
Yes.
And my lord, this particular issue is also not made of the fact of a joint obligation and agency is also not made out in the plain. Paragraph 33, he categorically binds himself to a joint venture. It is his submission that he has bound himself to a joint venture. So therefore, that particular aspect also goes. My lord, thereafter, I have whatever I have placed before my lord, it is at page 7. The last bit of the argument is at page 7. One important factor is both the Fakir Chand Gulati judgment and the Banga Daniel Babu judgment, which I have relied on, of the Supreme Court of 2008 and 2016 respectively, is the law that stands as on date. This particular definition of a joint venture in respect of development agreements has not been upset. Neither has my learned friend relied on any judgment to show the contrary. My lord, thereafter, he has the facts that he has relied on two judgments, one of Lord Grihanirman, which is in respect of our particular High Court in a Order 7 Rule 11. My lord, that particular judgment is distinguishable on facts, because most importantly, there is no agreement in that particular case. It is born out of a term sheet, and for that particular purpose, my lord, even in that judgment, I can just quickly indicate the relevant paragraphs. No, you have relied on the division bench. I had relied on the
I
single
had
bench. I
only
am going through
cited
the.
the division bench judgment to show that the single bench judgment cited by my learned friend is no longer good law because it has been
Very
undone
well.
by the division.
My lord, I was under the
That was the
impression that
limited
he has
submission.
relied on it.
Your single bench has been
My lord,
upheld.
I am on the division bench judgment, that the division bench judgment also holds otherwise, because there is no determination with regard to the term. It was an agreement. So the subject matter of the dispute was in respect of a term sheet, and an agreement was to be entered into. There was no agreement, which is why whether it would fall under a particular section or the other could not be identified. My lord, I will then only refer to paragraph 10 and paragraph 26.
Which one?
My lord, the division bench judgment, my lord. But since the single bench has now been uh, considered by the division bench in the same matter, my lord, it retains finality. I'm only relying on that judgment, my lord. Paragraph 10, the
Granirman.
Griha Nirman, page 13, paragraph 10, inviting our
Just a
attention.
minute, let me see.
My lord, sorry. It was a court, my lord, server copy, my lord. আরেকটা copy আছে?
ये जजमेंट बाकी का है यस
मतलब पैराग्राफ 10 पेज 13 एक कॉपी
पैराग्राफ 10
inviting our attention,
पेज 13
my lord,
यस
inviting our attention to certain paragraphs of the plaint. It is asserted that the disputes uh, arise from construction and infrastructure contracts as well as a joint venture agreement, thus qualifying as commercial disputes under both sections. He elaborated the issue and contended that the term sheet indicates that the project was intended to be jointly branded under the name of Merlin and the landowners, and according to the term sheet, the land would be provided to the landowners. So there was an issue of joint branding as well, which is absent in this case. And my lord, it would have borne all the costs and expenses associated to the construction and development of the land. Thereafter, my lord, kindly, it is a part of the submissions, my lord. I am not coming there, but mainly, my lord, paragraph 26 at page 18, it indicates,
yes
as noticed earlier, the learned single bench observed that the question raised in the application for rejection of plaint, it should be plaint, can only be determined upon appreciation of evidence, since the existence of the herein the term sheet is in dispute. So, my lord, the existence of that particular document was in dispute. Admittedly, there was no agreement, and on that basis, it could not be determined. But in this particular facts of the case, there is an agreement, and the agreement categorically indicates the roles of both the parties involved. So, my lord, this is completely distinguishable on facts, my lord. And with regard to the other judgment of Ashok Kumar Jaiswal that he has relied on regarding agency, I have already placed my argument that if it will fail on all three counts: one, not pleaded in the plaint; secondly, it will not be a joint venture if he is to act as an agent only; and thirdly, with regard to the fact that uh, once he is an agent, once he is my agent, it is for residential purpose, not for commercial gain or for trade use for trade and commerce.
yes
So, my lord, on this basis, I submit that my learned friend has failed to uh, prove that, or has failed to indicate that this would fall within the meaning of a joint venture agreement, and is it should be, the plaint should be returned. My lord, one more aspect that he has argued is the fact that this matter was referred to pre-institution mediation, on the basis whereof uh, since he has availed that particular remedy in law provided under the Commercial Disputes Act, it would automatically fall within the meaning of a commercial dispute. My lord, in my respectful submission, that cannot be so, because even the reference, the date on which it was referred to pre-mediation, it was an ex parte order passed against him where I was absent. My lord, at the very first instance where I could raise this objection, I have raised the objection regarding the jurisdiction, and merely because he has availed of a benefit which ought to have been availed with regard upon rather upon appreciation of the urgency of the situation, cannot be taken to be with regard to the substantive right in respect of each of the agreement. The particular plaint was not served on me on that date. So therefore, whether it would fall within that definition of a commercial dispute, I could not have taken the point. Whether the particular order is also a part of his uh, application, which is at page 253. When the matter was the initial plaint filed in CS 57 of 2023 was rejected.
why you are going there and there for the commercial suit 21C 13 clauses?
Absolutely, man, I am there.
Why you are going here and there?
I just wanted
Your
to.
same your argument should be restricted or not on 21C. Whether
Absolutely.
under which clause he is harping upon two clauses. That's all.
My lord,
Referring whether there is any clause in the 21C referring the matter to the mediation, it
No,
can
my
be a commercial suit.
no, my lord. Well, that would have been my submission. It would anyway, my lord, it is not a part of the note itself. I just wanted to highlight the point which he has made. And my lord, with regard to the application that he has filed,
This is only 2 clauses. You have to give reply to that. You are already given a
Given
reply.
the
Yes, for the part.
and my lord, with regard to his GA1, my lord, will kindly take up my note. I have been as brief as possible, point wise, what should be the case.
Yeah, you have given the written notes. I will go through.
My lord, if you will kindly consider that one possession merely on the basis of a photograph of a signboard, one cannot prove possession. He has made incorrect statements in the plaint that he is in possession, whereas entire service of
Possession,
the
what purpose? What purpose?
well,
to
he
bestow?
well, he intends to show that he is in possession, and injunction is required for that particular purpose. He is not in possession.
Okay.
It was evident from the fact that service and everything is done on me at that particular address, whereas his service is being carried out on a different address, and it is evident from contemporaneous records and even service of the summons, my lord. And the fact that there are photographs of signboard, it would not indicate any form of possession. What is important is page 9, paragraph the second paragraph. Under secondly, I have indicated that the entire pleadings regarding payments that were made to me are incorrect, my lord. Somewhere he has written that he has paid me 3.5 lakhs out of 5. In the plaint, plaint and petition, he has written that he has paid me 5 lakhs. And again, from the documents that are supplied, from those documents, it is reflected that only 3 lakhs has been paid, my lord. Out of the 3 lakhs, there is a money receipt which my learned friend has shown of 2.5 lakhs that were made over, my lord. From the particular money receipt, it would be evident that it is an incomplete document because it only bears my signature, and a date has been written which is evidently not my handwriting. From the signature and the handwriting, it will be evident. But after that, apart from that, if I come to the fact that contemporaneously, immediately after that date, after 2 days, he writes a letter. He says 3.5 lakhs is due and payable to me, and I have written a letter on 8th of November, which is this
fact. Again, you're coming to the
No.
fact.
So, my lord, someone who has made incorrect statements, has approached this court with unclean hands, is not entitled to any form of relief. Since he has also not proved that he has made 5 lakhs, he has failed to establish a prima facie case for
You
which
have mentioned in all the in the.
Yes, I
written
have
notes.
mentioned
Okay,
all
I
that.
will go through. Yes.
My lord, I am giving the judgment, which is the last judgment regarding prima facie fact case, if not made out.
Why new judgments are
This
being
is
cited in
This
reply?
is in regard to his application. This is my first opportunity to deal with his application. We are opposing his IAGA 1 is where I am placing. I am not going to go through the entire thing. Paragraph 16, my lord will kindly consider. This is the entire note. My lord, much obliged for a patient hearing, my lord. This is the entire note, my lord. Paragraph 16, unless a prima facie case has been established, even if there is any balance of convenience or any loss, irreparable loss shown, he is not entitled to any order of injunction.
Yes.
That is it, my lord.
Thank you.
Much obliged.
Yes.
Yes, my lord. My note so far as GA1 is concerned, it is ready.
Hmm.
But my lord, I need to deal with this new judgment that has been cited today.
Hmm.
And my lord, I'll revise this short note and then hand it over, my lord. My lord, just to quickly deal with my learned friend's note, my lord, kindly takes page 5 of his note. My lord,
Come on the next day. Come on the next.
very well.
Shall I submit a supplementary with these two letters?
No, my lord, I am opposing because
Suffering for the plaintiff, and suffering for the defendant. Counsel for the defendant has filed the written notes of argument and also concluded his argument. Police counsel for the plaintiff prays for a time to deal with the written notes of argument and the new judgment relied by the defendant in the case of reported in 2010 volume 1 SCC 689. Due to paucity of time, hearing the counsel for the plaintiff could not argue the matter. According case adjourned, let the matter appear on 7th February.
7th February. Great.
Next. Fixed matter, fixed matter.
Well, as far as item number 8 is concerned, ma'am, it's my application. My learned friend has won some accommodation only for today. May just be not today.
Not today.
Well, may it retain its position because my juniors have come from various places, like from Delhi.
Item number 8.
Yes.
Item number 8. 8.
Yes, ma'am. May it be kept tomorrow.
Item number 8. So applying for the plaintiff, due to paucity of time, matter could not be taken off and let the matter appear tomorrow.
I'm great.
इसको ऊपर कर देना करना नहीं फिर तो आप कमर्शियल आप लोग नीचे से ऊपर लेके आ जाएंगे
এগুলোতে এই রেন্ট রিসিপ্টস গুলোকে আমরা
keep note of it
এগুলো এডমিট করছো তো?
yes
না এই রেন্ট রিসিপ্টস গুলো করছি না,
তাহলে তার
rent এর
কোনটা এডমিট করছো তাহলে? আর তো সবই হয়ে
গুলো করছি যেটা
তো সব তো হয়ে গেছে তো আগে।
ওগুলো করছি না।
My lord, she would recall my learned friend had said that
yes
by consent it can go.
Yes.
What they are not consenting are, my lord, out of the 4 documents. In fact,
You can also exhibit it subject to objection and
But,
just ask whatever other questions you want to. I am my lord, I think my learned friend has done
up to
Up
my lord, PD 6.
6.
yes
My lord, then PD 9, 9 and 10, my lord, we are admitting. No objection also.
PD 9 and 10 admitted
Yes, yes.
But then, my lord, kindly, my lord, in the deposition itself, my lord, it can go in that by consent PD 9 and 10 are marked as
Yes.
exhibit G and H.
uh,
But I am separately giving the document so that they can mark it. PD 9 or PD.
and what about PD 10 11
My lord, those are my documents. PD 10, my lord, is
PD 9 10 exhibit can be exhibited
yes, G and H.
Exhibit E and F.
and what about the
Kothay?
6 and
Sorry,
7
G and H.
G and H.
Yeah.
what
G and-
about the 7
7 and 8, if they want, my lord, they can exhibit subject to my objection. According to me, my lord, that these documents are, my lord,
My lord,
not
let him, my lord,
genuine
I put it in when I put it in, my lord, they will say.
record
PD is 7 though.
क्या चाहिए
I am showing you an
Rishi
original document being PD number 7. What is this document?
My lord, this is the counterpart of the rent receipt issued by Karnani Properties Limited.
Where is the original rent receipt?
This is with the Calcutta carpet stores. Carpet stores.
In what circumstances was this receipt issued by the plaintiff?
This was issued against the payment of rent.
From whom was such rent received?
From Calcutta carpet stores, the rent was received.
Now, in the counterfile, you will find a initial. Can you identify the initial?
Yes. This is of one of the directors of Karnani Properties Limited, and the name is Mr. Akshay Karnani.
Lord, may I tender it?
that's subject to objection.
why
Lord, Lord, may I request him to step out, my lord, because same objection will also be there in the next set of documents. That's why I wanted him to step out. Or your lordship may record the objection. Or if your lordship wants, I can indicate in his presence also, my lord.
this goes
You know, their case is that I have paid them rent, they've issued rent receipt. My case is I've never paid them rent, and these, my lord, don't prove payment of rent. This document,
so your case is that this amount has not been paid by you
No, no amount, no rent has been
Correct.
paid
No
by
rent
me.
was paid by you.
This doesn't prove, my lord, payment of rent. Next important thing is, he is not in a position to prove this document because it's not issued by him, and therefore he cannot also explain the circumstances. So that therefore it is not, it's a document is not proof, B, my lord, nothing, the transaction is also not proof. So that is the objection.
Yes. With the Exhibit G with objection, as the defendant denied that they have not paid any amount, any rent. Yes, next.
My lord, pages 27 to 66 can also go in on the same basis.
Very well, my lord, let it go.
PD,
Let PD8
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 is also
appearing-
marked as an exhibit subject to
PD8 appearing at page number
27
27
to
to
66.
66.
27 to 66 of the judge's brief of document are marked as exhibit H collectively. Same objection. No?
Only one request, my lord. Kindly give me leave to cross-examine without
J.
prejudice.
Correct. You have the right.
That
This
is
is exhibit
Leave is
J,
not required.
collectively.
that is true.
কত হলো?
H collective.
H.
H collective.
In arbitration, we always ask, so I thought I'll. Not I accept, my lord. Once it's subject to objection,
Even though the exhibited document also you
Well,
can
I
cross
think
examine.
in the marking there will be some difference because we had
No.
done on the last day till exhibit F. Then in the
G.
morning G and H happened.
I
No,
and
only one.
No, two.
Two.
Two happened. So this will be J, my lord. I and J.
I
No, no,
and
ये
J
नहीं,
subject to objection.
इससे पहले दो रिसिप्ट
এই যে এটা
आया था
এটা এটা
You only
এটা I হবে ওটা J হবে আর G and H হচ্ছে যে দুটো এই যে
you have shown only one document Mr.
হ্যাঁ ওই দুটো আগে মার্ক হয়ে যাবে G and H G and H by consent তো অর্ডার হয়ে গেল
जाए ना
ওই কপি
First में
ডকুমেন্ট
जो first क्या था
অরিজিনাল ধরেই দাও না।
क्या था जी जी उससे पहले का नो दो चिप दो पहले क्या एग्जिबिट हुआ था
কি বলছে দেখ
पोलियो
Well, PD 9 and 10 is marked as exhibit G and H.
just last document was F
Last document was F.
F.
After that, my lord, when we started today, PD 9 and 10 by consent is marked as exhibit G and H.
PD 9 and 10 first
PD 9 and 10 is marked as exhibits G and H.
G and H PD 9 and 10 appearing at page number
But, PD 9 is at page 67 and PD 10 is 68 to 84.
67 and 80.
G and H.
With objection.
No, this is not. This is without objection. G and H is without objection. Then document I is also I is with objection. With objection. And then J order J is marked collectively by consent with objection.
Yes.
The brief cross-examination.
One minute, I have to শেষ করে নি, আর।
Not completed.
This is why we should have affidavit of evidence.
It will not take. I am showing you এটা with objection করে দেবো এই যে ফার্দার যেটা দেয়া হয়েছে সেটা
ও হ্যাঁ 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 রাইট হ্যাঁ করে দাও না
with objection.
yes everything
My
with
lord, this can
objection.
also be recorded, my lord, that
Document appearing at PD.
my lord, documents appearing at 4 documents under enclosure of letter dated 22nd January 2025 are marked by consent as exhibits কত হয়েছে J হয়েছে
J KLMN
K L M and N subject to objection. This is K
KLMN.
K তারপরে হচ্ছে 4 number receipt vouchers
K उसको बोलो यहाँ मत देखो बोलो K
চারটে তো
এটা হচ্ছে এল কালেক্টিভলি কে এল এক্সিবিট এল প্রপার্টি ট্যাক্স বিল
Objection will be decided.
স্যার এটা নো পেন্ডিং আছে
এটা লাস্ট এটা অবজেকশন দিই তো অরিজিনাল প্রপার্টি ট্যাক্স এনিওয়ে ঠিক আছে
Objection.
Property tax objection?
No, no.
এটা উইদাউট
Without
অবজেকশন কে এল ইজ উইথ অবজেকশন এম ইজ উইদাউট অবজেকশন
M.
and n is with objection. এটা কর্পোরেশনের নো আউটস্ট্যান্ডিং চিঠি
করে দাও না
উইদাউট অবজেকশন
হ্যাঁ
n is without objection.
according to me Milord, these don't
Government-
really make any difference.
Either you paid or the print.
No, he is paid.
No, either you paid or the plaintiff paid.
Yes, but on title of property it has no bearing. So that is
Yes, next.
What are you claiming in this suit?
We are claiming an eviction and vacant and khas possession of the suit premises.
Now, it is the case of the defendant that they have an independent right over the suit property. What do you say to that?
That's not correct.
No, that's all. Well, in previous days deposition, well, only one small correction. Instead of 27th, well, it should be 26th in question 16.
Question 60.
Yes. This is another letter which was issued by Calcutta Carpet Store, dated, it should be 26/11. Well, it has gone down as 27. Letter will speak for itself, but
उसमें कर देना.
26/11.
कौन सी?
Good.
Question number 16.
Yes, my lord. Answer to that, instead of 27/11, it should be 26/11. Last page.
2711.
It should be 26/11.
that with your lordship's leave.
Yes, sir.
Are you a director of the plaintiff?
Yes.
When were you appointed a director?
Sometime in 2002 January.
Were you involved in the business of the plaintiff before that day?
No.
How old were you in the 1980s?
1980.
80s.
I was about 10-15 years old.
Obviously, you had no idea about the suit property. You agree with me?
No, I had the idea of the suit property.
You are therefore deposing that when you were 10 or 15 years old, you had an idea about the suit property.
Yes.
Please give a considered answer.
Yes.
Yes. Have you met? No, just strike out, please. Are you aware of Hashmukh Rai?
Hasmat Rai.
Hashmat Rai. Are you aware of Hashmat Rai?
Means
Yes.
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 Have you met him?
No.
How are you aware of him?
According with the I was aware that he has written some letters which we found in the representing Calcutta Carpet Stores.
Representing
Calcutta carpet stores.
To Karnani Properties Limited.
Are you aware of Ramchand in the same way?
Yes.
Are you aware of Gopal Das in the same way?
Yes.
So your knowledge about Hashmat Rai, Ramchand and Gopal Das is restricted to letters dated 9th September. Exhibit number. Exhibit D, E, D and E.
Yes.
Oh, আজকে তো না এগুলোকে এখানে লেখো exhibit number K. Oh, yeah, just add to the question K. K. Would it be correct that upon death of Ramchand, now would it be correct that your knowledge about Gopal Das becoming a partner upon the death of Ramchand, partner of Calcutta Carpet Stores, upon death of Ramchand is restricted to the three letters being exhibit D, E and K?
Yes.
Are you aware that the firm Calcutta Carpet Stores stood dissolved upon death of Gopal Das in the 1980s?
No. We had no knowledge.
Are you aware that if there are two partners and one partner dies, a firm stands dissolved?
Yes.
Since you were 10 or 15 years old in 1980s, you cannot be aware of the exact nature of occupation of the suit premises. Do you agree with me?
In the 1980s, yes. We
Yes.
came to know when I became one of the director of the company.
Yes, then I came to know
Yes, I came to know when I become one of the director of the property in question.
from exhibit D, E and K. Is that your evidence?
Yes.
Do you know that the shop room was closed for considerable time in the 1980s?
No.
No. Do you know that in January 1990, Prem and Suresh Gyani, Gyani, entered into possession of the suit premises?
No.
Can you show any document by which you authorized, by which plaintiff authorized Prem and Suresh Gyani to enter into possession of the suit premises in January 1990?
No.
Can you show any document? I'm sorry, please strike out. Is it correct that before director হলেন 2002? May I request for the first answer?
Yes.
Two, na? Is it correct that no, sorry, not is it correct? I suggest to you that prior to 2002, you had no idea of exact nature of occupation and status of the occupant of the suit premises.
That is not a fact.
Not a
Not a fact.
Oh, দরকার নেই, কিচ্ছু দরকার নেই। shown Exhibit I. On this, you can show him the copy, there is no problem. কষ্ট করে original দেখাতে হবে। We can show him the copy, it will be, or you show the original. Exhibit I. Is it? No, I'm sorry, not is it. On the basis of this document, the plaintiff is alleging that rent for shop number 11 has been received for the month of October 2019.
Yes.
Full stop. Did you receive rent on behalf of plaintiff? Did you personally receive the rent on behalf of the plaintiff?
Yes.
Who prepared the document being Exhibit I?
This document has been prepared, signed by one of the director of the company.
Is it correct that no, please strike out. Is it your evidence that from 2002 you went around collecting rent from your tenants? You personally went around collecting rent from your tenants?
The tenants deposit the rent in our office.
So your evidence is that Calcutta carpet stores came to your office and tendered rent?
Yes. They tendered rent in our office.
Yes.
Yes, they tendered the rent in our office.
And such rent was allegedly tendered to you personally?
No, to one of my staff members.
In your presence?
That I cannot recall.
Is there a CCTV in your office?
Presently, yes.
When did you install the CCTV?
I cannot tell. Do not remember. I don't
When-
I
remember.
cannot say.
When did the defendant, according to you, for the last time pay rent? For the last time tender rent to you?
That is for the month of October 2019.
After installation of CCTV?
I don't remember.
I suggest to you that the document being Exhibit I is a fabricated, antedated document
That's not.
created. No, I'll finish the question.
Sorry.
Created by you for the purpose of this litigation.
That's not a fact.
I suggest to you that the document, the Exhibit I, has not been proved in evidence. Not correct.
question.
Not correct. Not
That
correct.
is the question.
Withdraw. কিছু দরকার নেই। Oh, ওটা হ্যাঁ। Next. Now please come to page 27. Now 27 being part of Exhibit J. এটা কি in order এ আছে? Page number wise শোনো? Order. The first page of the
MA.
this, according to you, is a receipt.
Receipt voucher.
Why is it not signed by the director?
I don't
not know. I don't know.
I cannot.
This is for this document, according to you, shows receipt of rupees 4697.
Yes.
Cash.
Yes.
Can you say who gave you this cash?
This amount,
Yeah, I'm sorry. Can you say the can you indicate the name of the person who gave you this cash? Who gave the plaintiff this cash?
that I cannot say.
This handwriting is also the handwriting appearing at page 27, part of Exhibit J, is also not yours. Am I correct?
Yes.
I suggest to you that one suggestion I'll give at the end with all. Now please take page 28, also part of Exhibit J. Whose handwriting is this on the bank slip?
This is my handwriting.
Sorry?
This is my handwriting.
Did you go and deposit this money with the bank?
Not me personally.
I suggest to you that this document, which is page 28 of Exhibit J, only shows that rupees 4697 was deposited by the plaintiff with the bank and nothing else.
This shows that rupees 4,697 was deposited in the bank, and the details of which are in the following page. The breakup, that is.
I'm showing you page 29, which is the following page that you mentioned in your last answer. I suggest to you this is a computer printout which has no signature and no authenticity and has been prepared for the purpose of this litigation.
That's not a fact.
I suggest to you that the rest of Exhibit J, which spans from page 30 to 66, are similar sets of computer prints, unsigned receipt vouchers, and bank deposit slips, which do not prove that anybody paid you rent.
I disagree.
I suggest to you that the authenticity, I suggest to you that these documents are antedated, unauthentic, and has been prepared for this litigation.
That's not a fact.
I suggest to you that the only thing which the plaintiff can prove from these set of documents is deposit of certain sums in cash with Central Bank of India and nothing else.
The amount that is being deposited in the bank has got details about the rent, have got details, the breakup, which shows that what amount was collected from different tenants.
The purported detail and breakup that you just referred to are in a purported receipt voucher and a computer printout sheet, which are unauthentic and show no involvement of the defendant.
I disagree.
What was the rent? What according to you was the rent payable by the defendant in 2013? I'm sorry, in 2013, December 2013. Now, please don't look at the document, just indicate. What according to you was the rent?
Cannot recall the exact. I think it was something 2,400. I cannot recall correctly. I have to check my as far as I can remember, it was 2,400. But I have to check
Now
my
see
record.
page 32, part of Exhibit J, and answer the question, please. Suggestion দিয়ে ছেড়ে দিন। হ্যাঁ?
कल्याण कल्याण इसको जेरॉक्स कॉपी
এগুলো বলো।
ये नहीं एग्जिबिट आई का कॉपी
বলে দিয়েছেন?
বলেন
এক্সিবিট এলটা দেবে, জেরক্স চলে গেছে, আমাদের কপিটাও বোধহয় চলে গেছে। কোশ্চেনটা শুনবে
না।
অরিজিনাল গুলো ওখানে থাকবে আর জেরক্স গুলো একটু বার করে নেবো, আমাদের সেটটা নইলে থাকবে না। না, ওটা তো অরিজিনাল।
দিয়ে দিন, আমি লাগিয়ে দিয়ে দিচ্ছি। দুটো বাঞ্চ আছে না, আরো আছে, 4টে বাঞ্চ আছে।
চারটে এরকম আছে।
यस
He hasn't answered, so I'm waiting.
व्हाट इज द आंसर
Uh,
हैव यू अंडरस्टैंड द क्वेश्चन हैव गॉन थ्रू द क्वेश्चन रिपीट द
No, my
क्वेश्चन
question is, if you
That is the first one.
December 2013. So he said, I don't exactly remember. It was around 2,400
It is-
something. So I showed him page 32, part of Exhibit J, and I requested the witness to answer the question again.
it is 2,800 per month
From page 32,
for December.
2013.
For December 2013.
But do you find at page 32 that you have the plaintiff is mentioning the rent was rupees 3,146 per month?
That is inclusive of the service tax.
Service tax which you have allegedly collected is not required to be paid on rent.
No, service
What do you
tax.
say to that?
No, service tax was required to be paid on rent from June 2007. 7.
I suggest to you that from 1990, from January 1990, no rent has been paid by the defendant to the plaintiff.
That's not a fact.
Since I suggest to you that the plaintiff has occupied the suit premises as owner defendant has occupied suit premises as owner in a manner hostile to the entire world.
Not a fact.
I suggest. Are you aware that the defendant obtained permission for repair of the suit premises from Kolkata Municipal Corporation?
No,
Are you aware that such repair was carried out?
no.
If I show you the application made by the defendant to Kolkata Municipal Corporation for permission to carry out repair, would you be surprised that there is no reference to the plaintiff as the alleged owner of the property? Application to that one. What do you say to that? The shown, लिखे दिन shown page 91 of Judge's Brief of Document.
This letter was issued to the Kolkata Municipal Corporation. The permission was sought by Calcutta Carpet Stores from Kolkata Municipal Corporation for repair of work.
Is it your evidence that your alleged tenants were in a position to apply from Kolkata Municipal Corporation for permission to repair without any reference to you?
Normally, normally the permission is required from the Kolkata Municipal Corporation to carry out any repairs within the premises. So that is why I guess they have obtained this permission.
I suggest to you that the defendant was occupying the suit premises as owner
That is not a
from
fact.
1990, which is why it did not need your permission to apply for permission to carry out repairs from Kolkata Municipal Corporation.
That is not a fact.
To your knowledge, was such repairs carried out?
I was not aware of such repairs.
I suggest to you that after obtaining permission from Kolkata Municipal Corporation, the police were informed by letter dated 16th October 2004 at page 93 of the Judge's Brief of Document, and repair work was duly carried out, of which the plaintiff is and has always been aware.
No, I was not aware.
I suggest to you that if the defendant, I suggest to you that if the plaintiff had any right in the property, they would have objected when the repair work was being carried out.
The plaintiff has always had the right in the said property.
I suggest to you that the plaintiff has not produced any document which would show that the defendant has paid any rent from the 1980s.
Not a fact.
I suggest to you that the defendant had occupied the suit premises from 1980s not as a tenant but having facets of ownership.
Not a fact.
I suggest to you that in any event, defendant has become owner by adverse possession, having regard to its continuous, open, uninterrupted possession as owner in a manner hostile to the entire world from January 1990.
I disagree.
I suggest to you that no rent was ever demanded by you or the plaintiff from the defendant, at least from January 1990, because the plaintiff was aware that the defendant was the owner of the property.
Not a fact.
I suggest to you that the Calcutta carpet store was constituted, Calcutta carpet store, a new and different partnership firm was constituted in January 1990 between Prem and Suresh Gyani as the two partners.
I was not aware of that.
I suggest to you that it is this business which got converted into the defendant.
I had no knowledge of that.
No. Which is- The name of the name of the defendant, a private limited company, is publicly displayed at the suit property since since 1991, and therefore the plaintiff was totally aware of such fact.
No. We were not aware of such fact.
Plaintiff, however, no, just 5 minutes. No, plaintiff. No, the written statement. Written statement. Plain down. I suggest to you that the plaintiff has failed to prove alleged payment of rent by the defendant as হয়ে গেছে না? The will strike off. Sorry. I suggest to you that no fraud has been perpetrated upon the plaintiff, as has been incorrectly alleged in paragraph 9 of the plaint.
Not a fact.
I suggest to you that existence of defendant in the suit property since 1991 was never concealed, and death of Hashmat Rai was always known to the plaintiff.
Not a fact.
I suggest to you that suit should be dismissed.
Not a fact. I disagree.
Further suggest to you defendant's counterclaim should be allowed.
I disagree.
That is all.
That's
Great.
shown. Shown exhibit I. तो कॉपी दो ना
তোমাদের আর witness আছে? Then I'll bring my witness, Miller.
that's all report huh?
আর কি করব?
Why it is mentioned as a tax invoice in exhibit I?
Because GST has been collected on.
Why it is mentioned it is of the receipt of 31/10/2019? Why it is mentioned rent increment from 2020 June 2022?
Normally, the rent increase after every 3 years. That is just a suggestion for my.
You have recorded the bill number 2055.
Yes.
Have you enclosed the bill along with the receipt?
The original is with the tenant, that is Calcutta Corporate Stores, my lord. This is just the counterpart of the rent receipt.
Yes.
That would your lordship permit us to come back after 2 weeks with our witness? We will have very short witness.
But I think it will go March. How many witnesses will?
হ্যাঁ?
Yes.
আরো আছে? No, I think one, Millard. If after that, if we have some, we'll bring Millard, but I think one should suffice.
So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. The counsel for the plaintiff brought to the notice of the court the answer of the question number 16, wherein date has been wrongly recorded as 27/11/1957 instead of 26/11/1957. Accordingly, the date is corrected as 26/11/1957.
adverse possession after execution
Plaintiff witness is present. Examination chief resumed. During his examination, documents were marked as exhibit I2,
an abandoned house.
G2,
Inside that,
M,
you can
N. Full stop. Examination chief is concluded. Full stop. Plaintiff defendant has also cross-examined the witness, and accordingly, witness is discharged. Counsel for the plaintiff submits that he will not adduce any evidence. Accordingly, evidence on the side of the plaintiff is closed. Full stop. Counsel for the defendant submits that he will adduce evidence on behalf of the defendant. Let the matter be fixed for defendant's witness. Please the matter give the date. Okay, you bring one day you complete the chief, then cross examination will be taken.
But if his chief is short, I will
Short
do
chief,
it.
Millard. Short chief.
Because-
If we have, Millard, more than one witnesses, we'll bring them all, keep
मेरा
2,
बजेगा
3 and 4 outside.
नहीं है 11:30 है कर रहा है
He'll go for a mission today to find witnesses.
17 February at 11:30.
But we'll take one more minute, Millard. Lordship must hear what Mr. Chaudhary said about previous witness in another suit in this court on adverse possession.
No, I was just telling him, Malad, this reminds me, Malad, Justice Pratik Prakash Banerjee, when he was in the bar, he was opposing an execution application. In the affidavit, it is written, and on oath, the person claiming adverse possession is writing, I was walking in the street and it started to rain heavily. So looking for a shelter, I saw an abandoned house, I entered there and there was no one. So I took shelter over there. And since there was no one, I permanently started staying over there. And this was an oath. So at that point of time, Millard, I am not naming the judge. Millard, the honorable judge expressed that irrespective of whatever I hold
Grateful, Millard.
Yes, next.
I am for the plaintiff, my lord, led by Shorojit Dashgupta.
Yes.
I am for the plaintiff in this matter,
Ah.
led by Shorojit Dashgupta.
My lord, this is this matter, my lord, Mr. Chauhan Gupta was appearing, my lord. My lord, he's addressing, my lord, Justice Shorkar on a continuing part heard matter, my lord. If my lord kindly takes it up on 7th of February, my lord, subject to my lord's kind consideration. Because my lord, today, my lord, from 12:30 also, my lord will taking testamentary matters, my lord.
So appearing for the plaintiff, so appearing for the defendant. As per the prayer made by the counsel for the defendant, the case adjourned. Let the matter appear on 11th February. 11th February.
11th of February.
Grateful, my lord.
Next.
Lord, this is the state's application. Lord, your lordship had taken up this matter on Friday. Lord, for extension of time to file the written statement, Lord, pursuant to leave granted, Lord, we had filed the written statement in the department, but within 120 days, and my lord, and served a copy on my land friend.
Lordship, I'm opposing this application precisely. I am opposing, Lordship. I believe there is insufficient explanation. There are two limbs to the provision. First is the 30 days, where an explanation needs to be affirmed as to what has prevented the defendant from filing the written statement. And the next 90 days is an explanation towards what was the reason for the delay. Lordship, that perhaps is not there in the affidavit.
Yes.
However, Lordship, subject to what my learned friend says suffices. Lordship, the affidavit is incomplete, I would say, with respect to a certain period of time. If my learned friend is able to satisfy your Lordship, then it's up to your Lordship's discretion. Now, with respect to exercise of your Lordship's discretion, my submission is I am prejudiced. I am prejudiced in the sense, Lordship, there are points, the number of grounds on which I intend to submit. Lordship, first of all, the defendant being a state was put on notice by a section 80 of the Civil Procedure Code. So the claim and the suit, the defendant is well aware. As opposed to a commercial dispute between two private parties, a state is well aware of the claim. Second comes, in a commercial suit, it is first of all a mediation process which is initiated. The moment a mediation notice is received, even my claim is determined, or rather the details of my claim and the basis on which I'm claiming is mentioned in the mediation notice. The state had refused to participate in the mediation process. Thereafter, I filed the suit. So previous to filing my suit or the service of writ of summons, the defendant was well aware on the basis of which my claim is established. Now, second comes upon receiving the written statement along with the writ of summons. Lordship, the defendant has stated in their application that they had ascertained from they were tracing. The word used is tracing of certain documents. Now, I have looked up the written statement that has been filed by the defendant. The basic documents which have been relied upon by the defendant are also the documents which has been used by the defendant in their suit before the Alipur Civil Court. Now, Lordship, if the defendant had already the documents in hand, there is no question of tracing them out. Therefore, I understand from the affidavit what has been affirmed is incorrectly, Lordship. What has been affirmed is, Lordship, false statements on oath. Now, Lordship, apart from this, Lordship is also aware that in view of the notification, or rather the circular taken by the state of West Bengal, that suits arbitration clauses shall be struck off. So therefore, the defendant, assuming that there is no arbitration clause, is well aware that any claim, especially when a plaintiff filing a claim with respect to unpaid bills, my claim is of supplementary claims as unpaid bills, are supposed to retain documents for at least 20 years as per the circular. So there's a question of tracing out documents also doesn't arise, especially for the state or a public authority. Lordship, apart from that, I am prejudiced, Lordship. These are my points why I am prejudiced, Lordship. Today, it's a commercial dispute. Had it been a non-commercial dispute, things would have been different. The whole intention of the statute is to move ahead on a fast-track basis. Now, retaining documents or tracing out documents, these stands perhaps is not available for the state. Lordship, these are my points for, Lordship, how am I prejudiced, Lordship, by their conduct. Lordship, apart from that, on merits, Lordship, the affidavit is incomplete with respect to explanation of the 30 days as well as 90 days, Lordship, separately. Those are my submissions, Lordship.
Yes.
But if your Lordship sees the timeline, my Lord, if I may just briefly indicate, Lord, before responding to my learned friend, my Lord, this is a suit which was filed on 17th of May 2024. My Lord, the writ of summons. Now, my Lord, there are 3 defendants, and this dispute principally, my Lord, arises out of a common contract, which was in the year 2012. My Lord, the dispute arose, my Lord, in 2014, 15, 16. My Lord, thereafter, my Lord, the plaintiff today has allegedly come that with a case that there are unpaid bills which are, my Lord, there. My Lord, the suit is now filed in 2024. If your Lordship sees, my Lord, from paragraph 5 onwards, I have, my Lord, your Lordship is aware, my Lord.
When you receive the writ of summons?
My Lord, writ of summons for defendant 1 was received on 21st of October 2024. Defendant 2 and 3 have received on 17th of November, 17th of September and 18th of September 2024 respectively.
21st of October 2024. When the 120 days over.
The 120 days over, not even over. 18th of February 2025.
Is the 21st of October taken?
The 21st of October, if it is taken.
When it is going to be over?
18th of February 2025.
February 2025. And what about the other?
The other twos have expired on 15th of January 2020.
When they are received?
Received on 17th of 17th of September 2024.
Summons.
Yes,
Writ of summons. And defendant number 3 on 18th of September 2024.
Correct.
The 128 days for defendant 2 expired on 15th of January. And 120 days for defendant 3 expired on 16th of January. Lord, we mentioned this matter, my lord, taking your lordship's leave.
When the affidavit, when the written statement was filed?
Lord, 13th of January 2024. My lord, it is already been filed and it is on record, my lord.
Where is that?
And the leave was granted by your lordships on 13th of January 2020. 13th of January 2020.
It was filed in the department.
It was filed on the very same date.
Okay. Then?
And we have also served a copy upon the copy of the written statement upon the plaintiff.
On 13 January or 14 January?
13th of January.
Yes.
Served on 16th of January.
Okay. Yes. Next.
The explanation, if your lordship sees it at page from paragraph 5 of my application. These are very old records, my lord, of 2012. My lord, the dispute arose in 2015 and 16, my lord. And thereafter, my lord, this suit was filed after a long period in 2024. But there are also issues of limitation also which is involved in this suit, my lord. But if your lordship sees, my lord, I have given explanation, my lord, sufficient cause has been disclosed in this application, my lord. Lord, there may not have been day-to-day explanation which I have provided, which may not be, my lord, the requirement also. But, my lord, if your lordship sees paragraph 5 till paragraph, my lord, 11, my lord, 12, your lordships will find, my lord, we have shown indicated sufficient cause in this matter, my lord. And there were many personal transfers, my lord, because this contract at this time when it was executed, my lord, there were a lot of transfers which had happened inter se between the departments, my lord. My lord, to get hold of all these documents and to acquire the knowledge, my lord, there was some time, my lord, which was required. Lord, so far as the notice under section 80 is concerned, my lord, and so far as the mediation process is concerned, my lord, that, my lord, perhaps will not be a ground for me that where I would, my lord, contemplate that, my lord, possible proceedings will be, my lord, initiated against me. My lord, even assuming that, my lord, I will still have to wait for the plaint to be finally served upon me to ascertain the final claim or the nature of claim which is made upon the defendant, my lord. So it is only upon receipt of the summons, my lord, when I'll be able to, my lord, or any party will be able to ascertain, my lord, what is the defense or the possible, my lord, the stand which has to be taken by a particular party.
Yes. That's all.
And insofar as, my lord, so if a lordship sees, my lord, the entire timeline has been complied with, my lord, insofar as, my lord, not within 38 days, my lord, which I have explained. There were vacations in between, my lord, which also, my lord, elongated the entire process. And at this, and, my lord, in the point of substantial justice, your lordship knows, my lord, my defense have to be, my lord, put on
Penal
record.
advocates have no vacation. Government penal advocates have no vacation.
But that's one of the ground, my lord.
Moving in the vacation bench and every time.
That's one of the ground. I'm not, my lord, even contending that's a major ground, but, my
You
lord,
have taken the ground, the vacation was there, advocate was not
one of the
available.
ground, my lord, the difficulty was to, my
how
lord,
the government standing counsel will take the stand due to the vacation, the advocate was not aware. It can be said the private advocate. How the government advocate can say?
But
you have not raised the bill of the vacation, of the consultation.
But the main difficulty.
Tell me.
Yes,
have you raised the bill of the vacation? Of the consultation? Show me. I am calling the report. I am calling the report with the consultation of the vacation you have taken the bill or not, then I will allow this application. How you have given on affidavit this? State cannot take a easy, sir. You give an oath that you have not claimed the conference of charges of the vacation. I am allowing here in now.
Well, your lordships, well, if I may be
I
permitted
will
to
call the
serve.
report from the department. Of these cases from the which date to which date, whether you have raised the conference bill or not.
Absolutely.
Please make sure before this court, government advocates cannot say that during the vacation advocate was not there. It is not. Instead of West Bengal is not having a one advocate. She is still appearing in the fore.
I bow down before your lordship. My lord, what possibly fallen from your lordship is to that extent may be correct, my lord, but the main difficulty here was, my lord, procurement of the papers. Your lordship is aware, my lord, but it had taken because it's a contractual dispute of 2012. My lord, to collate all the papers and to prepare the written statement, my lord, that my lord, took some time, my lord, for the
Generally
advocates,
don't
my lord.
interrupt when my learned friend makes submissions, but the very documents which they have appended to their written statement are those documents which is also their documents in their suit before the district court at Alipur. The same documents.
Sense offering for the plaintiff, sense offering for the defendant. Number all defendant 1, 2, 3.
1, 2, 3.
Defendants. The defendants have filed an application being GA Form 2 of 2025, praying for extension of time to file return statement. Counsel for the defendant submit that the defendant number 1 has received the writ of summons on 21st of October 2024, and the defendant number 2 and 3 have received the writ of summons on September 2024 and 18 September 2024 respectively. Police. The counsel for the defendant submit that time to file return statement of 30 days expired on 17th of October 2024. He submit that after receipt of the writ of summons, on 23rd of September 2024, the defendants have sought to find the records of the matter but could not trace the said documents, and immediately thereafter there was a puja vacation, and after the puja vacation, the defendant have provided the documents on 10th of November 2024 to the learned counsel for the defendant for preparing written statement. He submits that after taking instruction from the defendant, the advocate on record has held the conference and drafted the written statement, and during the drafting of the written statement, it was found that further document is required, and the defendant number 3 was not dealing with the work, and the predecessor of the defendant number 3 was not was coordinating with the persons for the documents and the connector to search the document connected with the suit, and subsequently all the documents have been corrected, and after holding conference, a written statement has been finalized and has filed before this court with the leave of this court on 13th of January 2025, that is within the prescribed period of within the outer period of 120 days. Police. Counsel for the defendant submit that if the counsel for the defendant submit that though the defendant could not file the written statement within the prescribed period of 30 days, but has filed the return statement within the outer period of 120 days and paid for extension of time for and paid for acceptance of the return statement which was already filed in the department on 13th of January 2025. Per contra, learned advocate appearing for the plaintiff has raised objection and submitted that the document which the defendant has taken, counsel for the plaintiff submitted, the defendants have taken the ground that the document could not be traced out is not correct. She submitted that initially the plaintiff had issued the notice under section 80 of the Code of Civil Procedure of the claim of the plaintiff, and subsequently the plaintiff has initiated the pre-mediation process with respect of the said claim, and the notices were issued to the defendant, and thus the defendants were much aware of the claim of the plaintiff even before filing of the suit. Counsel for the plaintiff further submit that another suit is pending before the Alipur court, and in this suit the defendants are contesting the suit, and the defendants have relied upon the document which is also the document connected with this case, and thus it cannot be said that the defendants were tracing out the said document. Another question was raised by the plaintiff that neither the plaintiff has shown any cause with regard to why the defendant have not filed the return statement within the prescribed period of 30 days, and the defendants also failed to disclose and shown any cause for delay in filing the return statement within the period of 120 days. Police counsel for the plaintiff submit that the reason which the defendants have shown are not acceptable, and the affidavit shown by the defendant is not correct, not true and correct, and thus the application filed by the defendant is required to be dismissed. Full stop. Had the learned counsel for the respective parties peruse the application. Full stop. Admittedly, the defendant number 1 has received the writ of summons on 21st of October 2024. Defendant number 1 on 17th of September 2024, and the defendant number 2 on 18th of September 2024. But the defendant number 3 has received the summons on 21st of October 2024. It is not the case that the defendants, it is not the case that all the defendants are intending to file separate return statement. From the application, it reveals that the defendants intend to file the return statement together. If the defendant number 1 and 2 have received the writ of summons on 17th and 18th September 2024, that is
1 minute has received on 21st of October.
What?
One has received on 21st of October.
No, 17 and 18 September in affidavit you stated, sir. Kindly see the paragraph 3.
No. But one is on 21st of October 2024.
21st of October.
But that's defendant number 1, and so far as 2 and 3 is concerned, they have received on 17th and 18th September.
Yes. Defendant number 1 bolna received on 21st of October, and defendant number 2 has received on 17th, and defendant number 3 has received on 18th of September 2024. The defendant number 3 has, and defendant number 1 and 2 and 3 have received the writ of summons a month prior to the writ of summons received by the defendant number 1. But it has not been explained by the defendants why the defendant number 2 and 3 have not engaged the lawyer immediately when they have received the writ of summons. Why the defendant number 2 and 3 have waited for the receipt of summons by the defendant number 1 and defendant number 1 till the month of October 2024. Police. The defendants have taken the further ground that the documents was placed to the London advocate on record only on 10th of November 2024. That is after the puja vacation. That is after the puja vacation. Police. If the documents were placed before the defendants on 24th of November 2024, 10th of November 2024, why the defendants have taken further time to complete the draft of the written statement till the 13th of January 2024? Till the month of January, 13th of January 2024. Full stop. The court failed to appreciate that the defendants are the authorities of the state of West Bengal. The officers of the state of West Bengal never closed during the puja vacation. It is only the courts having the puja vacation.
No, it's closed for almost 20 days, not. Office of the state is closed for almost.
Total office closed.
Yes, my lord. More than 20 days, my lord, it is closed.
Closed.
This full stop. Considering the above, this court find that there is the defendants failed to show sufficient cause for not filing the written statement within the period of 30 days. Full stop. But this court find that the defendants have filed the written statement within the outer period of 120 days. And as such, this court is of the opinion one opportunity should be given to the defendants to file the written statement subject to payment of cost of rupees 25,000 to the state legal aid service authority. Full stop. The written statement filed by the defendant, the department is directed to accept the written statement filed by the defendant subject to scrutiny by the department. Full stop. You have received the copy?
Yes.
The plaintiff, the defendants already served the copy to the plaintiff. Copy of the written statement to the plaintiff. There is no counterclaim.
No.
Any counterclaim? Full stop. And GA number so and so is disposed of. The defendants are directed to show the payment of cost to the state legal service authority on the next date fixed before this court.
But on this cost, not if I can just show this order, not where Miss Adhyam not had appeared for.
Their lordship, there were number.
No, then, but the state government.
Well
Mr. Sinha, I know. I am giving a private. I am not 5,010. No, government should aware. Government should aware.
Government not if lordship, not the practical difficulties. Not I can't.
Okay, 10,000.
Very well, but because it is legal aid, not we shall
10,000.
Yes, we'll happily.
No, it is not for you. It is the officials.
Yes.
Officers should aware in the commercial matters.
Substantial period was there before the puja vacation started. There was nothing.
Okay,
done.
Lord, when lordship hears the matter, Lord, you should know why this resistance will not on the merits.
No merits. I have. There's many things. There is a suit filed by the state also. Look.
Yes, next.
Great.
This is my application for amendment of a affidavit of asset.
Yeah.
But probate was granted by this honorable court on 17th August 2023.
Yes.
Thereafter, the advocate on record who was dealing with the matter.
When the probate was granted.
It was granted on 17th August 2023. The learned advocate who was at that point of time, the advocate on record, he expired. He expired on 8th of November 2023, and there was a delay in filing the inventory. And my lord, at the time of
so what is your prayer here now?
For correction of for amendment of the affidavit of asset, your lordship kindly comes to page 15. My lord, page 15 of my application. My lord, the face value, the testator was having some shares of Britannia Industries. Face value was of ₹1 each, but it was wrongly typed as ₹2. Your lordship kindly sees that ought to be amended, otherwise not in a position to file the inventory is not accepted, my lord.
That is the only.
That is the only, my lord.
Annexure B.
Annexure B, page 15.
Annexure, what is the affidavit of assets?
That is the affidavit of asset.
So and so appearing for the petitioner. The petitioner has filed the present application being GA1 of 2025, praying for amendment in the affidavit of assets. Counsel for the plaintiff submitted. This court has granted probate on
17th August 2023.
On 17th of August 2023. And probate was issued on?
Issued on, just give me a moment's time.
Probate was issued on
8th of November 2023.
8th of November 2023. Full stop. At the time of preparing the inventory and accounts, the petitioner came to know in the affidavit of assets, there is in the affidavit of assets at annexure B, 1B, within bracket 1, under the heading Britannia Industries, the face value is mentioned as rupees 2.00. Rupees 2.00, but it should be rupees 1.00. Counsel for the petition submitted. The said amendment is the amendment in the affidavit as mentioned above is required to be carried out. In view of the submission made by the counsel for the petitioner, this court handed the amendment as sought for by the petitioner in the affidavit asset will not change the nature and character. Accordingly, prayer A
and also prayer B.
Prayer A and B of the master summon is allowed. GA is disqualified. Next.
Lord, item number 20 is my application for grant of probate, my lord. The deceased testatrix is Evelyn Guha, and the executor before your lordship is the General Secretary of Belur Math Ramakrishna Mission, Swami Shubiranando. Now, what had happened here, my lord, one of the properties which has been bequeathed is outside the jurisdiction, and therefore we had to comply with the provision of section 283, subsection 3. Pursuant to the order passed by my lord Justice Mukherjee on 22nd of February 2024, there has been paper publication and report of the district judge is also received, but the property being in Uti within the jurisdiction of Tamil Nadu, it as I'm told, my lord, the no objection or the whatever the certificate is required is not being able to be issued rather by our court, because there is no interpreter available in High Court who can interpret translate Tamil to English.
Let us come in Tamil.
Yes, it has come in Tamil. That is what I'm told. The report should be before your lordship today. Report of the district judge, which is received. This is concerning a property which is situated at Uti. They couldn't translate. Otherwise, everything has been complied with. The paper publication and all, those have been done. And we have also paid the court fees, my lord, on 25th of November 2024. The entire court fees have been deposited. And we have written on 7th of January 2025 seeking the no caveat certificate, because that is what is required to be placed before lordship. But
unless it is translated,
unless it's translated, that can't be done. So the notice from our end, which we had given.
What do you require now?
That is
what
there.
Is
But
the prayer now?
my prayer, because if it is sent back again, obviously that would be time consuming. If your lordship looks into the paper publications and the other paraphernalias which we have already complied with, and if your lordship would consider allowing the prayer
Here,
in the application.
in the state of West Bengal, there is no translation department. Might be.
Maybe in the state, but in our High Court, I don't think there is anybody who can translate.
Court can direct.
Yes, then the court can direct.
Because every state, every administration is having the translated department.
Very well. So if your lordship would then direct.
All language can be translated.
Because otherwise, if it's sent back to Mathura, it will unnecessarily take a lot of time.
But how, who can pursue this? Who, can you
Guy
ascertain?
was here, but I don't find him now that.
Mr. Sinha is not here.
Yes, he's
Otherwise,
not there.
no government advocate is available here.
I,
Ramakrishna Mission.
but the beneficiary is also
The
Ramakrishna Mission. I
The
don't want to unnecessarily bring in a doubt in the mind of the court. Otherwise, in Golpark Ramakrishna Mission, I'm aware that it can be translated. But if your lordship will pass such an order, then I'll be naturally I have to convey and will be complied with.
They are the beneficiary.
But they are the beneficiary. Belur Mott Ramakrishna Mission is the beneficiary for the benefit of the mott which is maintained there in Ooty. It's only one of the properties of the deceased.
And who is the testator, executor?
Executor is the General Secretary of Ramakrishna Mission.
Not by name.
Yes, by name, Shami Shubiranando. He has been named.
Otherwise it will difficulty.
That is the difficulty. Otherwise, we could have even made that prayer before your lordship.
So you can ascertain. I am fixing tomorrow. You ascertain or bring some government advocate so that I
Then
can
my lord will pass it over for the day.
pass over.
Yes.
Come tomorrow.
If I manage to find someone prior to your lordship's rising, I'll bring it to your
Pass over,
lordship's.
pass over. Next.
My lord, item number 21 is also my application for grant of probate. Here, my lord, the compliance report of the District Court of Mathura has come. The compliance report is dated 30th of November 2024, but with my limited knowledge of the language of in which it is actually published, I find that 20th of November was probably the date when the publication took place. So from there, pursuant to the direction passed by our High Court, my lord,
As per our City Civil Code Act 283, whether it is applicable here.
my lord, the order which has been passed by Mr. Justice Mukherjee, we are just complying with that because 283 unless and until we give an undertaking.
283.
Yes, the language does not call
No,
for any.
283. No, if you go to the City Civil Code Act,
Yes.
283 has been deleted.
Yes,
for
but
the
so far,
Calcutta.
yes, for Calcutta. Now,
One of the advocate, Mr. Bethel, is arguing the matter.
Betal was
Betal was
your lordship passing Ravindra Shekhar Prasad, I argued.
first I first the matter in this because 283 is not required unless it is proved that any legal heirs are residing in the property in question.
no, but here in this case, at least, my lord, it's not the case because all the
That
legal
I have
heirs have
directed
given.
subsequently to this order, I have directed for publication.
Yes, but publications and all have been complied with in both the cases, rather in the previous matter as well as in this, my lord.
That matter
Paper
is-
publications
when
have
the matter
happened.
is being Mr. Bethel, because he had argued length, so I told him because that will I decide on that issue. I have decided, but totally it is applicable or not, it has not been decided. Then I will decide.
But in my case, my lord, so far as this matter is concerned, the compliance report has come.
Yes, it has.
So it can now be granted because the paper publication took place in May 2024 and July 2024, and the matter.
Yes, he has done that.
Yes, so everything is complied in this, and the order which was passed by our High Court was dated 3rd May 2024, making the matter returnable 10 weeks since the date of publication. Now, publication in newspapers have happened in May and July, one in the English daily and the Hindi daily. And thereafter, your lordship will find that the in Mathura also the publication happened on 20th of November. about which the compliance report is dated 30th of November. So from 20th of November, even if I calculate...
No cavities?
No, that is not given, probably because I am told by my briefing solicitors that 10 weeks is due to expire on, my lord, 29th of this month. And today we are on 27th. So if your lordship looks into the order that was passed by Justice Apurva Sinha on 3rd of May 2024,
Yes.
that was made returnable 10 weeks since.
So I am fixing on the first week.
My lord, first week of February, if your lordship would be
Correct.
kind enough to keep it.
So and so appearing for the petitioner. Counsel for the petitioner submits it in compliance of the order dated 3rd May 2024, the petitioner has taken up to petitioner for issuance of citation under section 283 subclause 3 of the Indian Succession Act 1925, and accordingly the report has also been forwarded by the district judge. Report.
Mathura.
Already forwarded by the district judge, district Mathura, stating that the notice has been published. Full stop. The counsel for the petitioner draw the attention of this court to the order dated 3rd May 2024, wherein this court has fixed the time of returnable date 10 weeks from the date of fixation of the publication. Accordingly, the publication was made on 21st of May 2025 and 21st of July 2024 and 21st of July 2024. Thus, 10 weeks has not been
And no, my lord, from there, if we count, yes, 10 weeks have lapsed. But from the publication in the district court itself, that took place on 20th of November.
No, not the publication was made at the Mathura district on 28/11/2024. 8/11/2024. Thus, 10 weeks has not been completed. In view of the above, the case is adjourned. Let the matter appear on 6th of February.
Grateful to your lordship. Oh, my lord, instead of 6th, if it could be accommodated on any other date. 6th, I have some personal
10th?
difficulty. 10th is okay.
10th.
Grateful to your lordship. If Sinha was here, I'll just find out from him and I'll come back.
You find it?
Yes.
Whether the translation department and Tamil to English.
Yes. I think he's going to speak to the registrar.
Grateful to Raj. I'll mention it before rising then.
Yes, next.
My lord, I beg to appear on behalf of the petitioners. My lord, my application for grant of probate.
Yes.
Yes. My lord, if I may show your lordship the will.
Huh?
My lord, the will. My lord, is dated 1st May 2016. This is at page 12 of my application.
1st May
2016, my lord. At page 12.
Yes, 16.
My lord.
Who is the executor? Who is the testator?
My lord, testator is Haranarayan Taparia.
Haranarayan Taparia.
My lord, his death certificate is at page 11. He expired
Now,
on.
where is the name of the executor?
Yes, my lord, kindly see is page 12. My lord, 1, 2, 3. I hereby appoint my daughters. My lord, at page 12. Lordship found.
Bangur,
Uma Maheshwari and Mamta Bihani as
the
joint
executors.
Yes.
Executrix.
Executrix.
Executrixes.
Yes.
All three.
Yes, your
All
lordship.
three are the petitioner in.
Yes, your lordship. Your lordship will find the signatures at page 6.
So when the testator died?
My lord, testator expired on 5th March 2023.
Where is the legal heirs?
My lord, legal heirs I have stated in my lord para 2, page 3 of my application.
Wife.
Yes, my lord, wife has given consent.
Daughters. Where is the consent of the wife?
My lord, consent of affidavit of the wife is at page 15 of my application, my lord.
Page
15, my lord, 1-5.
Raj Dulari Taraparia.
Taparia, yes.
One of the legal heirs, and this is no objection hereby significant. Yes, then what about the three daughters? They are the daughters.
Yes, my lord, they are
What
the
about
applicants.
the attesting witness?
My lord, attesting witness, my lord, the affidavit is there separately, my lord.
Where is that?
My lord, this is an.
Who is the attesting witness?
My lord, Sri Gopal Dharak.
Sri Gopal Dharak.
Yes, your lordship. Lordship, the notarial certificate starts with the name Shane Cardos. Lord, affirmed on 4th May 2023.
I am one of the attesting witness. Yes. Then?
My lord, thereafter, my lord, citation had been issued under section 283. My lord, since two properties were located outside, my lord, one in Bombay and one in Maharashtra.
Correct.
My lord, no caveat has been received. Your lordship had called for a report on the last occasion. My lord, the report would indicate, my lord.
No caveat has been filed. So appearing for the petitioner. What is it? The petitioner has filed the present application for grant of probate of the last will and testament dated 1st May 2016 of the testator Har Narayan Taparia, Taparia. Will counsel for the petitioner submit that the testator has executed his last will and testament while possessing good health and fit state of mind by appointing his three daughters as joint executrix of his last will and testament. He submitted that the testator died on 5th March 2023, leaving behind three daughters and his wife. His wife, Raj Dulari Taparia, has also filed her affidavit of consent, stating that she has no objection for grant of probate to the executrixes. Full stop. The counsel for the petitioner submit that the will was executed in presence of two witnesses. Out of the two witnesses, one witness, namely
Sri Gopal Dharak.
Sri Gopal Dharak, Dharak, has executed an affidavit stating that the testator has executed his last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind by appointing the three daughters as joint executrixes of his last will and testament. Police counsel for the petitioner submit that some of the properties situated outside the state of West Bengal, accordingly citations were issued, but none has come forward to raise any objection or file any caveat. Accordingly, the department has submitted no caveat certificate stating that no caveat has been lodged. Counsel for the petitioner submitted the petitioner has proved the will and is entitled to get the probate. In view of the submission made by the counsel for the petitioner, this court has considered the original will, death certificate of the testator, affidavit of consent of the wife of the testator, affidavit of the attesting witness, and the no caveat certificate. This court finds that the attesting witness in his affidavit has categorically stated that the testator has executed his last will and testament by appointing his three daughters as joint executresses of his last will and testament while possessing good health and fit state of mind. Full stop. The department and the citations were issued, no caveat has been filed, and the department has submitted certificate stating that no caveat has been lost. Considering the above, this court finds that the petitioner has proved the will, and considering the above circumstances, this court finds that the petitioner has proved the will and is entitled to get the probate. Police Sapera, the department is directed to issue probate of the last will and testament dated 1st May 2016 to the petitioners upon compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA 205/2023 dismissed. Next. Yes.
It's not available.
Not available. So what can be done?
Then should we try on the basis of going by independent interpreters?
Is there any independent interpreters are there in the West Bengal or Calcutta?
Independently, probably I'll get because
Do that.
and then let me try my luck. If your lordship will permit that way, then I'll come back.
Record an order. Item number 2.
No, this is item number 20.
Item number 20. So appearing for the petitioner. Full stop. Counsel for the petitioner submit that as per the order passed by this court, comma, the petitioner has taken appropriate step for issuance of citations under section 283 within bracket 3 of the Indian Succession Act, and accordingly the district judge of Ooty has submitted the report. District judge of district Ooty, comma, Tamil Nadu has submitted the report, but the said report is in Tamil language. Due to which the department is not in a position to submit the report whether it is the objection or it is the no objection. Full stop. This court wanted to this court ascertain whether any Tamil translator is available in the state of West Bengal, but it was informed from the bar that no translator of the Tamil language is available in the state of West Bengal.
With the High Court.
With the High Court.
Not with the,
In the
in the High Court is not. We have official translators in our High Court, but not for Tamil.
No, your state government. I wanted from government. In your government.
Bengal has or not.
State of West
High
Bengal.
Court is not there. Otherwise, they could have
That's
taken.
why I knew.
I'll
I
find that.
thought-
State of West Bengal.
That
will
I
definitely
wanted
be.
to, because in every state, in every administration, translation department is there, and every language.
I'll find that out. Not an
If it is not also, they
I
can.
informed only about the High Court, not
No,
about the
that
state.
I knew.
वो काट दो क्या बोला ना वो काट दो दिस कोर्ट इंटेंट्स ना ऊपर ऊपर क्या बोला हाँ वो पूरा काट दो full stop. In view of the above, this court directed the petitioner to ascertain whether any Hindi translation department is available in the state of West Bengal, or the petitioner also given a liberty to ascertain whether any independent Tamil translator is available in the state of West Bengal, and to inform this court by the next date fix. Let the matter appear on 10th of February 2025.
My lord, would it be your lordship's pleasure to give a direction on my client to get it translated and bring it?
First you inform whether it is available or not. Then if it is, then I will direct.
Very good. Then
If
may
it
a
is
short
available
date-
in the state,
Yes.
then I will send to the state. If it is not available, then I will direct to the private.
Then may a short date be
10th,
given? 10th itself. Okay.
February.
Grateful to your lordship.
I appeal for the petition in this matter, my lord. Before, my lord, today I will not be praying for grant because I should not. The lordship kindly takes the petition once.
What is the prayer now?
My prayer is, my lord, twofold prayers. First is, my lord, if your lordship kindly comes to paragraph 7, one of the brothers have died.
Paragraph 7 of petition?
Of the application.
Probate application?
Probate application.
Yes.
One of the brothers have died, man.
Who died?
One of the brothers of the testatrix. My lord, in the will, there are names of the heirs of that brother. If your lordship comes to the will, that is at page 10, that starts at page 10. At page 12, E, F, and G, these are the three heirs of the deceased brother. So, my lord, I think it is my duty to bring these 3 heirs now instead in place of the deceased brother. I'll make an application for amendment. Now, my lord, the problem is there are 2 executors named in the will. Both of them had applied for probate. One is a renowned solicitor of this court, another is the brother of another brother. The brother who is the executor is above 85 and extremely unwell. He's off and on to hospital and home. I'm praying, my lord, if your lordship kindly grants me leave so that the amendment application can be filed without the signature of another. Both have applied for. If your lordship kindly sees this cause title, both the executors are applicants before your lordship. So if your lordship kindly grants me leave, only one executor will sign the amendment application. Sharat Kumar law is very unwell. Sharat Kumar Laha.
No, so you wanted to implead whom?
I want to implead
CD.
heirs of Vishwanath Laha.
CD.
C, E and E in the will.
Who are the A is the son of the brother.
Yeah, another brother, man. Another brother. So Vishwanath Law's heirs are only at page E, F, and G. If your lordship sees E, F, and G, Kumari Shunatra Law, daughter of brother Vishwanath Law, Master Shubhodip Law, brother of Vishwanath Law, son of my brother Vishwanath Law, and Kaveri Law, wife of Vishwanath Law. So these are the only 3 years of Vishwanath Law. Vishwanath Law has expired. So I'm praying that these 3 be brought on record.
Vishwanath Law expired when?
Death
After
certificate
filing
is
of the
also
case, after filing of this application.
After filing. After filing.
Yes, because you are not mentioned. Yes, yes.
No,
yes.
it is
No,
mentioned.
before, yes,
Before,
1st September 2020.
Before. Inadvertently, they should have implemented them. If my grants me leave, then it's a verified petition, we can just put in.
So appearing for the petition.
Let's be recorded first.
Counsel for the petition submitted. The petitioners have filed the present application for grant of probate. Full stop. In the will, the legal heirs of the brother of the legal heirs of the brother of the testator, namely Vishwanath Law, has been described as Master Shaudip Law, EF
and G.
Kumari Suntara Law, this one, E Suntara Law, Master Shaudip Law, and Srimati Kaveri
as the wife.
Full stop. This Vishwanath Law died on 1st of September 2022, but inadvertently the legal heirs of the Vishwanath Law have not been made as party in the instant, has not been described as a legal heirs in the present application. Accordingly, the counsel for the petitioner intend to file a supplementary what you want
amendment
intend to file an amendment application to bringing on record the names of the legal heirs of Vishwanath. Counsel for the petition submitted that there are 2 executors, out of which one of the executor is about 80 years of age and is suffering from severe ailment and is not in a position to execute the application, and he prays for leave to file the application by one of the executor. Considering the situation, considering the circumstances as mentioned, and considering the submission made by the counsel for the petitioner, one of the executor is granted leave to file the application for amendment by bringing the legal heirs of the deceased Vishwanath Law on record within a period of
2 weeks.
2 weeks from date.
2 weeks.
Next.
This is my lord, an application for grant of probate. Testatrix is Shankari Mollik.
Testatrix?
Yes, my lord.
Where is the will?
Will is at page 12. And translated form of the will is 18.
What is the name? Shankari Malik.
Shankari Malik.
Where is the translated copy of the will?
18, page 18.
There is no pagination. Shankari Malik, yes. Where is the name of the executor?
Next page, page 19, second para. I have taken decision by the will that Sri Rupak Dotto, son of Sri Tarapada Dotto, only grandson of my elder sister, that Shobharani Dotto, wife of Vishwanath Dotto, shall become the owner with all kinds of rights and or share belonging to me.
Where is the executor? Where is the word executor? He is being a beneficiary. Where is the executor? He has been appointed as the executor.
Petitioner is the executor, my lord.
Huh? Who is the petitioner?
Rupak
Rupak
Dotto.
Datto.
Rupak Dotto.
Yes. Where is the executor appointed as the executor?
If you find in page 15 in Bengali will,
I appoint him as the executor. Yes. When he died? When she died?
19 November 2020.
Death certificate.
Death
Shankari
certificate
Malik,
is
1911
11.
2014.
Page 11.
Yes. How many legal years?
She is issueless, my lord, and her husband was died on 7th April 1995.
What is the name of the husband?
Amurendranath Mollik. Death certificate is in Annex
95.
C. Yes, my lord.
Date of death?
7th April 1995.
Correct. No issue?
No issue.
Where is mentioned in the application?
Page 4, my lord. Page 4, para 8.
Paragraph?
8.
Yes. Citations issued?
Yes, my lord.
No caveat certificate has received?
Yes, my lord.
What about the attesting witness?
Prashant, one was died.
One died.
One was died 12th April 2023. I have mentioned it page 3, and another is Prashant Kumar Dotto.
Where is that? Where is that? Prashant Kumar Dutta attesting witness. Yes. Instances suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament. Dated. What is the date of the will? Dated
15th October 2014.
15th October 2014. Of the testatrix. Of the testatrix. Name Shankari Malik. SHANK Shankari Malik. Counsel for the petitioner submitted. The testatrix has executed her last will and testament in presence of two attesting witnesses while possessing good health and fit state of mind. By appointing the petitioner as sole executor of her last will and testament. Counsel for the petitioner submitted. The testatrix died on 19 November 2014 and 19 November 2014. The husband of the testatrix was predeceased to the testatrix, who died on 7th of April 1995. In the wedlock between the testatrix and her husband, no issue. There was no issue. There was no issue, and the petitioner has categorically stated in paragraph 18 of the 8 of the present application. Counsel for the petitioner submitted. After filing of the application, citations were issued, but none has come forward for raise any objection for grant of probate of the last will and testament. Accordingly, the department has submitted no caveat certificate dated 6th of December 2024, stating that no caveat has been entered in for grant of probate of the last will and testament. The petition submitted. Out of the two attesting witness, one attesting witness also expired, and another attesting witness, namely Prashanta PRS and Kumar Datta, has filed his affidavit stating that testatrix has executed her last will and testament in his presence while possessing good health and fit state of mind, and in presence of the another attesting witness, by appointing the petitioner as sole executor of his or last will and testament. Had the learned counsel for the petitioner peruse the original will as well as the translated copy of the will in English. Full stop. This could also consider the death certificate of the testatrix and her husband. Full stop. This could find that the department has submitted no caveat certificate certifying that no caveat has been lodged for grant of probate. The attesting witness of the one of the attesting witness of the will in his affidavit has categorically stated that the testatrix has executed her last will and testament in his presence and in presence of another attesting witness on 15th October 2014 while possessing good health and fit state of mind by appointing the petitioner as sole executor of her last will and testament. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate of the last will and testament dated 15th October 2014 on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA 231 of 2023 is disclosed. Next.
Grateful.
So this is my application under section 283 subsection 3 of the Indian Succession Act. Lordship, one of the properties is situated in district Bikaner, state of Rajasthan. I was praying for an order in terms of prayer A of the master's servant. Lordship. I have annexed a copy of the affidavit of assets in the affidavit in support of the master's servants.
Which portion?
Lordship,
Which property?
Lordship, it appears at page 6, Lordship.
Page
D3.
D3.
Lordship.
Joint ownership and such property.
In the village. Village in Tehsil, Lunkaran, sir, district Bikaner, Rajasthan.
This one. Only one property.
Only one property.
So offering for the petitioner. Petitioner has filed the present application being GA2 of 2025 under section 283 within bracket 3 of the Indian Succession Act, 1925 on the ground that one of the property as mentioned in the affidavit of asset is situated outside the jurisdiction of the state of West Bengal and is situated at village and Tehsil, Lone Cancer, district Bikaner, page 6. Consider the submission made by the counsel for the petitioner or use the affidavit of assets. Prayer A of the master summon is allowed. GA2 it is for. Yes.
I am for the petitioner. My application for grant of probate, my lord. The testatrix, my lord, is the ready, my lord, Chintamani Dasi, my lord. Will pays, my lord, 14, my lord.
Chintamani Dasi?
Yes, my lord.
Yes. What is the date of the will?
Will dated, my lord, 19th, my lord, 14 November 2019, my lord.
Yes.
Page 14, my lord.
Where is the
Bengali
name of the testator? Executor.
Executor, my lord. Kindly come to, my lord, page in Bengali, my lord, page 16, my lord. Internal page 3, my lord. Last Otro Ile Ami Amar Konishto Jamata.
I want in English.
Yes, my lord. In translate copy, my lord. Page, my lord. Page, my lord, 27, my lord. Page 20, first paragraph. I am hereby appointing my younger son-in-law, namely Sri Uttam Saha.
Where it is?
Page 27, my lord.
There is no pagination here.
Translate copy, my lord. Internal page 3 of the translate copy, my lord.
Yes. I am appointing one younger son, namely Uttam Saha.
Yes, ma'am.
Occupation so and so as executor.
Yes, ma'am.
Who is the petitioner? Uttam Saha.
Uttam Saha, ma'am.
When he died?
Died, my lord, on my lord.
She is the executor, testatrix.
Yes, my lord.
When she died?
15 January 2020.
Where is the death certificate?
Death certificate is, my lord, page, my lord, page 30, page, my lord. Page, my lord, 29, my lord.
15 January 2020.
Yes, my lord.
What is the date of the will?
Date, my lord.
19.
Yes, my lord.
14 November 2019.
Yes, my lord.
And where is the legal attesting witnesses?
Attesting witness, my lord.
How many attesting witnesses?
Attesting witness, my lord, 2, my lord. 1, my lord, the Gaudhori, Maiti, my lord. Gaudhori, Maiti, my lord, give the affidavit, my lord. File affidavit.
Gaudhori and Sanju Das.
Yes, my lord.
Where is the legal heirs?
Legal is on page 4 of the petition, my lord.
4, 5, 6. How many legal heirs?
Legal heirs, my lord. A2, my lord. A2, my lord. J, my lord. My lord. All are
Son, daughter, daughters, son. Yes. All are given no objection.
Some give no objection and some.
Who has given no objection?
Tapos Saha.
Just a minute. Let me see. Where is the Tapos?
Tapan Saha, my lord. Tapan Saha. Annex with this petition, my lord.
Huh?
Annex with this. Yes,
there's nothing here.
Separate.
ये देखो तपन सा का है.
Yes, my lord. Dated, my lord.
Affidavit है.
17th October 2023, my lord.
Sanjay Shah.
Yes, my lord. Next, my lord, Sanjay Shah. Yes, my lord.
Then Bharati Shah.
Bharati Shah also.
Anjali Shah.
Anjali Shah.
Then
Mrityunjay Shah died, my lord.
Mrityunjay died. Mrityunjay died.
Died. Rekha Shah, wife of the Sanjay Shah, died, my lord. He Oisi Shah.
Oisi Shah.
He give the consent, my lord.
Oisi Shah. Preeti Shah not. Then
Preeti Shah and Sudipta Shah.
Preeti Shah?
No, not give, my lord. And my lord, Sudipta Shah not give, my lord.
The minor.
Minor, my lord.
So,
and my lord,
what can be done regarding minor?
I have served, my lord, through, my lord, their mother, my lord.
Mother. And what about the Sasti?
Sasti Saha, my lord.
Sasti what?
Yes,
Died.
no, my lord. My husband died on her husband, my lord.
Where is the Sasti?
So, citation issued, my lord. Citation issued, no caveat certificate was given, my lord, by the department.
Well, attesting witness?
Attesting only Gaudhori Maiti, my lord.
Huh?
Gaudhori Maiti, my lord.
Who is Devashish Manjunda? Gaudhori?
Maiti, my lord. Upon on, my lord, upon 17th October 2023, my lord.
So suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 14th November 2019 of the testatrix Chintamani Dasi alias Chintamani Dasi CHINTAMANI Mani Dasi. Counsel for the petition submitted the testatrix has executed the last will and testament while possessing good health and fit state of mind by appointing the petitioner as sole executor of his last will and testament. The testatrix died on 15th of January 2020. What about the husband?
Husband long page 32. Died after the execution of the will, my lord, but kindly come to page 23, my lord.
Huh?
Page 32, my lord. Page 32, my lord.
What is the name of the husband?
Swasti Charan Saha, my lord. Wife, my lord, Swasti Charan Saha.
32 is something else.
32, annexed E, my lord.
And the husband died on 19th May 2023. The testatrix died behind A, B, C, D, E, F, G, H, I, J. About 10 legal heirs. 10 legal heirs. Out of the 10 legal heirs, 5 legal heirs have submitted their no objection for grant of probate. And other legal heirs have neither given the no objection nor have filed their affidavit, caveat or affidavit in support of caveat. He submit that citations were issued, but in spite of the citation, none has come forward to raise any objection, and accordingly, the department has submitted no caveat certificate on 7th of December 2024, certifying that no caveat has been lodged for grant of probate. Full stop. The petition submitted, the trustees have executed a last will and testament in presence of two attesting witnesses. Out of the two attesting witnesses, one of the attesting witness, namely
Gaurhari Maiti,
Gaurhari Mathi, has filed his affidavit stating that the testatrix has executed her last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executor of her last will and testament. Also for the petition submitted, the petitioner has proved the will and is entitled to get the profit. Had the learned counsel for the petitioner produced the application, this court find had the learned counsel for the petitioner full stop produce the original will, death certificate of the testatrix, death certificate of husband of the testatrix, affidavit of consent of the legal heirs, and the affidavit legal heirs, no caveat certificate issued by the department, and the affidavit of the attesting witness. From the report of the department, it is found that no caveat has been lodged for grant of probate, and the attesting witness has categorically stated that the testatrix has executed her last will and testament in her presence, in his presence, and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executor. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate of the last will and testament. According full stop, the pit and the department is directed to grant the probate of the last will and testament to, on compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number
draw and complete is not required, my lord. It is grant of probate, my lord. Draw and complete is not required, my lord.
As this is the probate, and this is an application for grant of probate, and as such draw and completion is not required. It's not required. Yes, call the list.
Lordship, Lordship, may I have may I be allowed to mention for a leave?
What leave?
I want to take a leave to file affidavit as well as
Not this time. Come in the morning.
morning.
My lord, in the matter which has been called, my lord, the one which is fixed at 2, I'm appearing on behalf of the plaintiff.
I'm for the respondent.
We are at the stage of arguments.
Yes.
Your lordship, my lord, had heard this matter on 13th of December, where Mr. Sen was leading me. Now, Mr. Jishnu Shah, learned senior advocate, my lord, has been engaged in this matter. And your lordship knows, my lord, that there was a bereavement in his family. After that, he mentioned the matter because it was fixed today. There is some urgency as far as the plaintiff, my lord, is concerned because his properties are going into, my lord, proceedings before the Debt Recovery Tribunal. Any day, your lordship feels, my lord, give us some precedence, my lord.
Fix then, you know.
My lord, argument stage, we won't take much time.
Correct, but
My lord, I know, my lord, I am there before your lordship. But if some precedence can be given, it is true, my lord, 6 crore 24 lakh, my lord, is at stake. I have a document also to show. This is proceedings, my lord, are happening.
Yeah.
At least, my lord, several forum. Debt Recovery Tribunal notices have been received with respect to the properties which are, my lord, involved. Some precedence can be given.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. The matter is fixed today, especially fixed today for argument, but due to unavoidable circumstances, counsel for the defendant.
I am for the plaintiff.
I'm for the defendant.
It's not in person to argue the matter and paid for our adjournment. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on. Give the date. How much time will take?
Well, a day's time we are going to finish. We'll try in a day's time. 1 hour. One session which your lordship usually gives for 45 minutes.
March. There's no date in my diary.
Can't even rely on some lucky date.
Commercial?
It's a commercial matter. An undefended suit.
Undefended?
Yes, only right to cross-examination was there.
Let the matter appear. Undefended. Witness action?
No. At the stage of arguments.
That's why argument.
Yes, only cross-examination, my lord, was
examination is
allowed.
done.
So, my lord, not much to argue on behalf of the defendant.
Matter appear on 11th February.
But may it be 12th instead of 11th?
12th is Wednesday. Non-commercial day.
The week after that, because 11th, I'm told Mr. Shah.
18th February.
8. But at any time, we'll be there. We'll be there. Of course, it will be taken. I'm deeply obliged.
Yes, call them.
Lord,
yes.
Kindly, my lord, take the civil procedure code once.
Item 4. Fixed matter.
Give the CPC.
Fixed matter. Bengal ne jito.
Lord, I want to, my lord, place order 23.
Yes.
Lord, kindly, my lord, take order 23. Rule 1. Withdrawal of suit or abandonment of part of claim. At any time after the institution of a suit, the plaintiff may, as against all or any of the defendants, abandon his suit or abandon a part of his claim.
Yes.
Now, my lord, come to Rule 3. Order 23, Rule 1, Sub-Rule 3. Sub-Rule 3, my lord.
Yes.
Where the court is satisfied
Yes.
that a suit must fail by reason of some formal defect, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or a part of the claim, it may, on such terms as it thinks fit, grant the plaintiff permission to withdraw from such suit or such part of the claim with liberty to institute a fresh suit in respect of the subject matter of such suit or such part of the claim. So therefore, my lord, under Order 23, Rule 1, a plaintiff is entitled to abandon, as a matter of right, a
Correct.
suit or any part.
No problem.
Under 1(3), he may have leave to institute a suit afresh, and if he does so, court may, my lord, after consideration of the request, grant him leave. Objections, my lord, for withdrawal with leave are to be considered by the court, my lord, granting the leave. You may or may not grant leave.
Correct.
Now, grounds are formal defect or sufficient grounds for allowing plaintiff to institute, or any ground considered fit, or formal defect. Now, Lord, may I show your lordship AIR 82 Calcutta, page 17. I don't know, my lord, what would be the response, but to my recollection, when on the first day before the learned arbitrator observed that there is a problem in the absence of the bank, I will not be in a position to adjudicate an injunction matter. My lord, Lord said that yes, it can be both ways. You may also grant an order in personam, but if you strictly go by it, it may be a problem. And I'll want to consider and come back. From my learned friend's junior was appearing, not a word. Then on the next date, when I said that it is probably better that I go back and I file a suit as per your observation yesterday, not a word of objection. Objection to leave being granted has to be taken when the leave is being granted. If you don't take that objection and leave is granted in the subsequent proceeding, this is not a ground which can be taken. And what is very surprising, my learned friend Mr. Bhattacharya was not there, but his junior was there. His junior was aware that leave is being granted, leave has been sought for, and not an objection. No, this is a matter of law, my lord. No, these are things I take very seriously. I would never do this. Now, my lord, kindly have a look at Boi Ashini. My lord, may I just AIR 82 Calcutta, page 17. Lord, may I hand up my book?
AIR
Boi Ashini keno? Ritovan?
1982 Calcutta.
My lord,
17.
yes, my lord. AIR 82 Calcutta, page 70. I'll print it and my lord submit it by 4:30. My lord, paragraphs 6 and 9. My lord, please see, my lord, paragraph 6. The effect of the withdrawal from the suit is that the parties are left to the position which they occupied before the suit was filed. This view was taken in the case of such and such, in the bench case of such and such. Sri Bijan Kumar Mukherjee, presiding over the bench, has followed the aforesaid case of such and such and stated that when court grants leave to file a fresh suit or proceeding on the same cause of action, the withdrawn suit has no existence in the eye of law. It is available for no purpose, and the parties are relegated to the position which they occupied before the suit was brought.
Yes. Yes.
So, my lord, then paragraph 9, since the plaintiff of that suit was permitted to withdraw from it with liberty to sue afresh, in the eye of law, there was no existence of any such suit. Consequently, the findings arrived at in the earlier suit have no effect on the present suit. It is therefore held that there is no question of res judicata. That's a different matter. You know, it is on the same principle that if I withdraw a suit with leave to file afresh, the limitation is not saved, because this suit which I am withdrawing with leave to file afresh, did not exist at all. So that's why, my lord, limitation will never be saved. Before the next court, for example, in this court, I'm coming with new proceeding. In new proceeding, I'll have to say that I was bona fide proceeding in wrong forum. But, my lord, the court allowing withdrawal cannot, my lord, give me benefit of limitation because that proceeding upon leave being granted will cease to exist.
Why? Section 14 will not applicable.
Section 14, my lord, is continuation. Yes, but for the new court. My lord, same, this is the view, my lord, in all these. I'll also show your lordship another judgment now, my lord. Kunta. Nah, 87 Calcutta, Supreme Court 88. My lord, when the, my lord, for the purpose of, my lord, limitation, that will not be considered to be a proceeding which will save limitation. The fact that I bona fide proceeded before wrong forum is a factor which the next court will take into consideration. But any observation made in that suit or, my lord, any other order made in that suit will not survive.
That I am not on that. See, suppose this you file the suit, proceeded. Subsequently, if I know this is not, I have to go to the other. Then you have to file before the other forum. So by that time, your limitation gone.
Yes.
So what would be that?
I have to file that proceeding and pray for exclusion of the time in this proceeding under section 14. That, your lordship, is absolutely correct. So this will, but these judgments say that it will be effaced.
No, this is with regard to correct.
Yes.
See,
but for the new proceeding, this will be taken into consideration. That is correct. That is absolutely correct. Now, my lord, I want to show your lordship another judgment on withdrawal because impression was given to your lordship that plaintiff went to the learned arbitrator. First plaintiff went to section 9 court. Section 9 court did not extend interim order. So plaintiff went to arbitrator.
I am not with regard to withdrawal or file.
Yes.
My specific question is, initially you filed section 9.
Yes.
Correct. You got the interim order.
Yes.
Subsequently, you went to the arbitrator. Then in the same proceeding, when the court has found that you already been invoked the arbitration clause, appointed the arbitrator. So court has given a 3 months time, extended the 3 months time till the arbitrator, you take appropriate step before the arbitrator. Now you have gone to the arbitrator and filed an application under section 17. And the 17 subsequently you have withdrawn and now you file the suit.
With leave of the arbitrator.
Correct. Suit. Leave or not leave, you file the suit.
Section 17 therefore does not exist.
Correct. 17 does not exist. Okay, leave aside the section 17 does not exist. I appreciate your argument. So section 7. So this court can say that there was no section 17.
Yes.
Correct. As per this judgment, there is no section. This is a new suit you have filed. Now, if it is new suit has been filed, but why the court at this stage interfere with that once you have already invoked the arbitration proceeding and you have a right before the arbitrator?
Then the question is whether I have a right before the arbitrator or not. The arbitrator felt I did not have a right, which is why
that's why I'm again.
No, arbitrator granted leave.
That court has granted leave with your prayer. As per your prayer.
But that's an adjudication.
The court has arbitrator has not adjudicated. No, since this court is cannot look into the section 17, it will be difficult because the triparty agreement. That's why you have liberty to take up that the court could have been understand.
No, Millard, may I submit, Millard? The whole problem is different. Whole problem is your lordship is given an impression of two things. Number one, once he didn't get an order in section 9, he was sent to arbitrator. Then he didn't get an order before the arbitrator. Now he has come back. Now, these are, I don't know where this comes from.
Leave aside the impression.
No,
leave aside
no,
the
no.
impression.
But everything must have a legal basis.
I have not heard Mr. Bhattacharya. Now, that's why my only simple question is that once you got the interim order under section 9.
Correct.
Correct. And subsequently, when the interim order was granted, you invoked arbitration proceeding, appointed the arbitrator. You have appeared before the arbitrator. And at the time of disposal of the Section 9 application, the court has extended the interim order for 3 months or 3 weeks, whatever it may be. And in the meantime, you have been asked to take appropriate steps. So you have taken appropriate step before the arbitrator. You have taken the steps, but you have withdrawn that. Now you are taking the ground that withdrawal of the Section 17 application says that there was no Section 17 application before the arbitrator. There was no Section 17 application before the arbitrator.
No, please look at it in a different way.
So now the question is that once you have invoked Section 9, you have initially obtained the interim order. That interim order was extended by the same court under Section 9. How now you can pray the same order in the suit? Once you invoke the arbitration.
May I give a legal answer to this?
I want the legal
answer.
Correct.
Not these, my lord, dishonest.
No. I want the legal answer.
Legal answer.
Ask him to rein his horses.
No.
Dishonest.
I am mentioning your junior.
Mr. Chaudhary, see.
My lord, I don't like it. I am making it clear. Of course, I will reiterate it again.
Not to make any comments.
I am the last one
against
to
each
make
other.
aspersions. But, my lord, Order 23, Rule 1 is an adjudication. I'll show Supreme Court judgment on this. My lord, I am not saying something wrong. I'll show Supreme Court judgment on this. When I pray for leave under Order 323, Rule 1 to file suit afresh on same cause of action or file other proceeding, matter will be considered. It's a judicial order passed. No objection taken. So therefore, you have no objection at all to new proceeding being filed. If you had taken an objection, matter would have been decided by arbitrator. You sit quietly. Then order is passed. Then when matter comes before court in the second proceeding, you go and say, no, I have objection. It is not permissible in law. Okay. It is also not permissible ethically.
Okay, continue.
Yes. This is what, my lord, is, if I may use the expression, hurting me. Okay. You could have taken the point there that this is not permissible. Today, why are you giving an impression?
See, Mr. Chaudhary, you are also the lawyer.
Yes.
Correct. The other side also the lawyer. So lawyers will make appropriate submission. They feel where the submission is to be made.
If permissible, if honest.
Correct. If a party might be, I am not arguing.
If honest.
If the party has not, you wanted to withdraw. If you wanted to withdraw the file, the suit, why he will object?
No, if just withdrawing, there's no scope of objection. Correct. Because it's my right.
Correct.
But when I am, my lord, praying for leave to file afresh.
Okay, continue.
My lord, please see, my lord, and let me give a legal answer. Forget prejudice points.
Answer, not here and there. I want the legal answer on this.
Then, now, my lord, I'll just indicate. Let us, my lord, see what is the answer what is the order which I seek and whether it was permissible before the arbitrator. First question. Yes. My lord, please see 1978, Volume 1, All England Report.
1978.
Volume 1, All England Report, page 976. My lord, this is one of the first judgments on this point.
Page
976. My lord, kindly, my lord, I'll be very quick, my lord, because I have got many judgments to cite. My lord, please come to page 981. Barcode 981. At 981.
981.
Law report print নিয়ে এসেছো। Paragraph number হয় না All England report.
না পেজ নাম্বারটা বলে কেন?
Page number law report page number. My lord, it is the law as to performance bonds.
এটা তো
Sir, kindly give me 1 minute, my lord. Yes, my lord, page 771 of the print which your lordship has.
Yes.
This is the law report print.
Yes.
My lord, please see 771.
Correct.
To this, my lord, the law as to performance bonds. Bond is a new creature insofar as we are concerned. Then to this general, next paragraph, to this general principle, there is an exception to the case of what is called established or obvious fraud to the knowledge of the bank. This is, my lord, the crucial aspect. My lord, any bank guarantee injunction to be obtained, you have to show, my lord, fraud or fraud and fraud to the knowledge of the bank, apart from other factors. So the crucial, my lord, aspect of the decision making is knowledge of the bank. Otherwise, you'll never have cause of action.
Correct. You have to inform the bank first.
Yes.
If any
Now, my lord, please turn over to the next page. Let the last sentence. So as one takes instance after instance, last page, my lord.
Yes, yes.
Last line.
Yes.
Though these performance guarantees are virtually promissory notes, and below the next paragraph, all this leads to the conclusion that performance guarantee stands on a similar footing to a letter of credit. A bank which gives a performance guarantee must honor that guarantee according to its terms. So, Milord, when we say that the bank guarantee is, Milord, being invoked contrary to its terms, which is another limb, Milord, added by our Supreme Court, it's, Milord, the bank's duty to honor the bank. A bank which gives a performance bank guarantee must honor that guarantee according to its terms. So, obligation of the bank, it's an order which I'll seek on the bank. Then bank must pay. So, my lord, this I wanted to show your lordship, my lord, for the purpose that it's bank's obligation.
Yes.
Now, the next judgment, my lord, is also an English judgment. 1984 one All England Reporter 351.
1954.
84, my lord, I'm sorry. 84 one All England Reporter 351. My lord, two paragraphs, but one of the most celebrated judgments, my lord, which, my lord, tells the court not to grant ad interim injunction on restraining bank guarantee. Often, always cited by the defendant in appeal and quoted, my lord, extensively. But, my lord, I want to, my lord, use it for a different purpose. Second paragraph, judges who are asked, often at short notice and ex parte, to issue an injunction restraining payment by bank under an irrevocable letter of credit or performance bond or guarantee should ask whether there is any challenge to the validity of the letter, bond or guarantee. If there is not, or if the challenge is not substantial, prima facie no injunction should be granted, and bank should be left free to honor its contractual obligation, although restriction may well be imposed upon it, and freedom of the beneficiary to deal with the money after it is received. Wholly exceptional case when injunction may be granted is where it is proved. Now, kindly see what is proved. That the bank knows that any demand for payment already made or which may thereafter be made will clearly be fraudulent.
Correct.
So, my lord, in the world of, my lord, bank guarantee injunctions, it's, my lord, knowledge of the bank which is the cause of action. That you, the bank, despite knowing that this is fraudulent or contrary to terms, you're permitting payment. That's my cause of action. So, my lord, in the absence of the bank, I literally have no cause of action. 90% of the sting is gone. Now, my lord, see 1997 1 SCC 568.
1997.
97 1 SCC 568. Paragraph 12. This judgment, my lord, is engrafted, followed by Supreme Court, and this is the basis of the principle, my lord, laid down by Supreme Court. My lord, please see page 574, paragraph 12 on the next page. Bank must pay according to the tenor of its guarantee on demand without proof or condition. There are only two exceptions to this rule. First exception is a case when there is a clear fraud of which the bank has notice. The fraud must be of egregious nature, such as to vitiate the entire underlying transaction. Explaining the kind of fraud that may absolve a bank from honoring its guarantee. And Milord, this is the other judgment which I just cited. So, Milord, again, Supreme Court now accepts, and this is the basis of future law, that bank has notice of fraud and still, Milord, pays. That's my cause of action. Now, Milord, fraud, it's also fraud to attempt to invoke a lapsed bank guarantee. It's also, Milord, fraud to invoke a bank guarantee contrary to its terms. So contrary to terms is a part of fraud, and now, my lord, is also considered an additional limb to obtain an order of injunction, which has been laid down by Delhi High Court for the first time. May I quickly, my lord, show your lordship those judgments. My lord, 2006 SEC Online, Delhi 67. But that's good. তো হাত পা নাড়াও। ইন্টারটোল এটা নয়, এটাই হ্যাঁ। Milord, Milord, principles are summed up at paragraph 10. I just want to draw your lordship's attention. Milord, please see paragraph 10. Principles which may be distilled from the aforesaid judgments and the observations. Lordship has seen, Lord, the bank guarantee is an independent contract between bank and beneficiary. Then C, duty of the bank. Once documents are in order, bank has to honor in C.
Yes.
F, Milord, underlying contract disputes have to be resorted to by litigation or arbitration. And Milord, exceptions under H for Milord, exceptions.
Why not J?
Sorry, Milord.
Why not G?
D.
G.
Court should. Yes, Milord. This is very, very important. But this is one of the few cases where a petitioner can actually come, Milord, boldly and ask for injunction. Because bank guarantees have lapsed. It's not possible in terms of the bank guarantee.
Unless extended.
I'm sorry, Milord.
Unless extended.
Unless extended. Unless extended. Now, but if I had come during the tenure of the bank guarantee and I had obtained an injunction, then I would have been under an obligation to extend it. But here, my lord, they have rendered it a situation where it is not possible for them to invoke the bank guarantee.
So there is no contract. There is no clause in the contract with regard to the extension. If
No. Because the purpose for the bank guarantee has come to an end. That's a different matter in arbitration. But the contract very clearly says that within this particular time, they should have asked us to extend the bank guarantees. Milord, kindly see J. Milord, exceptions to the rule 1, 2, I and J. In case bank guarantee is not invoked in terms thereof, bank can refuse to honor the bank guarantee. As in that case, it would not be in accordance with the agreed stipulation and invocation would be improper. This can be treated as a fourth exception. As in such a case, injunction is granted. So, my lord, this is now that additional factor. Normally fraud, special equity, irretrievable prejudice, and invocation not in terms. Fourth, my lord, factor. Now, show your lordship, my lord, Hindustan construction, not invocation, not in terms. 1999, 8 SCC 436. Paragraphs 9, 10.
Page.
436. 9, 10, 12, 13, and 21. 5 paragraphs. Not 9, 10, 12, 13, and 21. Look, this was a case where only, my lord, a particular functionary, like an engineer, assistant engineer, could, my lord, invoke the guarantee. Invocation by another person
Whether
was
the
found to
authority,
be
what
wrong.
is the who is the authority to request
Only he
for,
can.
who is the authority to
To
request
invoke.
for the invocation?
Correct. Let please see 99, 8 SCC.
Here the assistant engineer has requested.
Yes.
The executive engineer was the, or the
Yes.
superintending engineer was the power.
Mr. Nariman's brainchild. Lordship would see, my lord, argued by Mr. Nariman. Paragraph 9, my lord. Last sentence. To the middle of the paragraph. Terms of the bank guarantee are material, extremely material, since bank guarantee represents an independent contract between bank and beneficiary. Both parties would be bound by the terms. Invocation will have to be in accordance with the terms of the bank guarantee, or the invocation itself will be bad. So this is what I am on. This is what was cited. Same, my lord, law followed in by the division bench of our court. 2009, 4 CHN, page 22. 3 bank guarantees in that case.
Page
22. Please see, my lord. কি বলছিস?
Which paragraph?
My lord, paragraph 13, 14, 15 of my book, my lord. My lord, 3 bank guarantees. 2 were, my lord, I'm sorry, 4 bank guarantees. 3 were invoked.
Already invoked.
Yes, and 1 wasn't invoked.
Correct.
The 3 which were invoked, injunction granted. It was held, my lord, that invocation was contrary to the terms. But because the 4th one wasn't invoked, the order vacated. Because we don't know what the invocation is about. My lord, kindly see, my lord, paragraph 13. After hearing the learned counsel. 13, my lord, after hearing learned counsel for the parties and going through the terms, we find that the bank had undertaken to comply for letter of invocation. Then, my lord, paragraph 15. From the aforesaid demand of the appellant, it is clear that the invocation was not in terms of the bank guarantee, and thus the bank was not obliged to honor the same. Learned trial judge was justified in passing an order of injunction, restraining the bank from making payment on the basis of demand is not in conformity with the terms of invocation, because there was no assertion of the appellant that the amount claim is by way of loss, etc., etc. So, invocation not in terms. Following Hindustan construction. Another, my lord, argument, what my learned friend correctly, my lord, points out, there also there was an arbitration agreement in the principal contract. Lord, please see paragraph 7, the first objection. Barred by section 8 of the Arbitration Act, because in the main contract there was an arbitration clause.
Yes.
Also, main contract had a forum selection clause. हाँ,
My lord, if your lordship may kindly explain this.
Not following Hindustan construction, injunction sustained. Suit was found to be maintainable. Naturally, because the guarantee, my lord, under the Contract Act is a tripartite agreement.
Yes.
Now, my lord, important judgment, my lord. This very objection, my lord, taken and considered. 1992, Volume 2, Bombay Current Reports. না 2000 এটা দে না বাবা 92 to bomb here 82 to bombs here তাড়াতাড়ি
What is the page number?
Milord,
Current report?
132 para 7. Huh? No. কি বলছিস Milord, I'm কি নেই Milord, I'll cite the next one. Milord, I'll just send for a print. Milord, 2021 SCC Online Calcutta 2986. এটাও কোথাও কিছু খুঁজে পাবে না
2196.
Yes, Milord. 2986, Milord. 2986.
Justice Bhattacharya.
This is Milord. This honorable single bench judgment of this honorable
Yes,
court.
Justice Bhattacharya.
2986. Milord, what is Milord? Also, something very interesting I found yesterday. Lordship will see there's a AIR Calcutta citation. If you take that judgment, it's absolutely different judgment. In fact, when Mr. Banerjee was telling me over a
It
video
happens,
call,
my lord, the SCC online. My lord, I was doing an arbitration before Justice Dave, Anil Dave. So I found out a very nice passage on a particular provision of law reported in AIR 45 Calcutta. Going to the SCC website, no discussion.
No,
I pulled out the judgment from AIR. That entire 3 paragraphs was missing from the SCC online version.
a totally different judgment, same cause title, in the same matter, there was another judgment that is reported in AIR.
And my lord, the biggest,
not this judgment.
My lord, the biggest mistake is, my lord, we rely on official trustee versus Sachindranath. That by consent you cannot confer jurisdiction.
Correct.
My lord, there is a note in the main AIR report that is missing from the SCC online, and the entire meaning of the judgment changes. I immediately called them up. I said, please rectify it because this is most relied upon judgment and the meaning completely changes.
This is what ante party na ante party paragraph 18 and 20 of this judgment, my lord. Kindly come to paragraph 18. The cases shown on the subject of bank guarantees should be seen in this context. In Hindustan construction, the Supreme Court stressed on the invocation being in terms of the bank guarantee and the requirement of special equities. The Supreme Court was of the opinion that special equities existed in favor of the appellants since the defendants did not have sufficient funds to complete the work. The other set of decisions, namely such and such, are for the proposition that while the jurisdiction of court under Section 9 of the Act can only be invoked by a party to the arbitration agreement, Section 9 does not limit such jurisdiction to pass interim measures only against party to arbitration agreement. The Bombay High Court specifically pointed out that orders are regularly passed restraining banks from releasing payment under bank guarantees, though the bank may not be a party to arbitration agreement. So, my lord, the objection was on jurisdiction, saying the bank is an independent entity, not a party, my lord. So
How the arbitrator can pass an order?
No, how the court under section 9 can pass order. So there, my lord, court held that under section 9, I can pass an inherent part.
Correct.
If your lordship takes it even further, procedure, my lord, and substantive rights of a court, my lord, always attach. So your lordship's power under section 9 as inherent power of the High Court is different from arbitrator's inherent power. Though now it's been held by Supreme Court that arbitrator also has inherent powers, but those are much lesser inherent powers
Than the court, yes.
procedural powers. But your lordship's powers are much further, much wider.
No, that's correct. No. So how would it will be helped?
How this will help? So, my lord, when I move a section 9, bank can be made a party, and your lordship, even though bank is not a party to the arbitration agreement, bank and your lordship can also, my lord, pass an order restraining invocation of bank guarantee. You kindly read it once more, my lord.
That's when section, because here this is not the section 9. Section 9 you already invoked and you got the order.
Yes. So I could have filed a section 9. I could have, because I'm entitled to make the bank a party.
That's what I'm telling. That's why since beginning I am telling.
So the question is, can I, my lord, make the bank a party similarly as I did in the section 9 before the arbitrator? I cannot. So if I cannot do that, will I become remediless? What will I do in that case? I can't come to 9 and say confirm my order, because now if your lordship sees the language of section 9, after constitution don't entertain.
Correct.
Except
that's why nowadays under section 9 we are not passing an order for the limited period. It is up till when the arbitrator
is appointed. So now what do I do? The only option, the unique situation, only option is to go before the arbitrator and say, my lord, continue the order in personam, in the absence of the bank. But if the learned arbitrator is absolutely sound and says that, no, look, invocation of bank guarantee, bank is a necessary party, which is, my lord, Bombay CR, which I wanted to cite. Then the question is, what do I do? I have only one option. I have only one option.
That is the question.
One option. To, my lord, file a suit for invocation of bank guarantee. On what ground? Number one, the bank guarantee is a separate contract. There are three parties to the bank guarantee: bank, beneficiary, and me. Tripartite agreement. Number two, this is distinct from the terms of the main agreement. So, my lord, I can file an independent suit. I can, my lord, file an independent suit for restraining
arbitration agreement will not affect the bank.
No.
Okay. Let us see.
And that is what Bombay says. Milord, I'll milord ওরম ভাবে দেখানো উচিত না। রাজস্থানটা দেখাও। Milord, kindly see the Rajasthan judgment, paragraph 5.
When your last date of the interim order?
6th
February.
February.
Okay.
Now, my lord, no, I want to, my lord, now show what is leave. I have all, my lord, taken out the judgments also. সব দেখাবো। Let one, my lord, to digress for just 1 second, if today your lordship, my lord, passes an order, I do not object. Can I object in appeal? Can I file appeal and say I'm person aggrieved? I answer it no.
No, I am not considering their appeal.
No.
And their objection with regard to the filing of the.
It's just on pure jurisdiction. I'll satisfy your
I
lordship.
am not on that also. I am telling in open court. I am not on that with regard to the objection you have withdrawn and filed. I am not on that. On my only the question is that how this court now go into the matter to pass an stay order once the court has invoked under section 9.
I'll satisfy your lord. That is,
You have
my lord,
invoked-
not the issue.
You have invoked
Yes.
that
my lord,
under
I will,
section-
my lord. I've got the
that is-
judgments for that.
That is the only thing.
Let me then
That is the
straight away,
trouble
my lord,
here.
come to that. First, my lord, kindly see. I've shown your lordship 82 Calcutta. What is leave? Then, my lord, see 20 AIR 87 Supreme Court.
So what do you want to this 14
My
SCC
lord, this
Rajasthan?
is also, my lord, paragraph 5, my lord. Kindly see paragraph 5.
Section 9 and in the present proceeding for restraint.
Miss, this was it. This was, my lord. No, this is section 37 appeal from a 9. Now, my lord, kindly see paragraph 5. It's discussed. It is required to be stated that the appellant had sought the relief before the court below in application under section 9 and in the present proceeding for restraining the respondents from encashing the bank guarantee without impleading the bank IDBI Mumbai as party respondent in the proceeding. It is needless to say that unconditional irrevocable bank guarantee is issued by the bank in favor of the respondents at the instance of appellant. If the appellant had filed the proceedings for interim measures seeking injunction against the respondents, restraining them from encashing bank guarantee, bank would not only be proper party but necessary party. So, my lord, our old concept of taking bank guarantee injunction in section 9 in personam really is now frowned upon by court. If you file a 9, you have to add the banker party and you can never get this order in a section 17.
Whether in the section 9 you have made a party to.
Yes. That is the problem which we faced. The arbitrator, first question is, can you do it in section 9? So we explained that yes, you can. And this was in the bank's presence. But bank can't come to arbitration. So now what do I do? Only option is take leave because 9 court has referred the matter to 17 court. Now I'm stuck in 17 court. But if there is a formal defect in the form of the action before the section 17 court, only option is seek leave, come out, file a suit. And that leave I have been granted. Now, my lord, please see Order 23, Rule 1, leave effect. Please, my lord. Yes, the Bombay judgment also, my lord. This is that Bombay CR which I, my lord, referred to. My lord, please see paragraph 7. Canara Bank is a necessary party for adjudication of the dispute as to whether respondent is entitled to encash bank guarantee in question or not. Canara Bank is not a party to arbitration agreement in question. In my judgment, the question as to whether the defendant should be restrained from invoking bank guarantee or not cannot be referred to arbitration having regard to the ratio of decided
Which
cases.
paragraph you are reading?
7.
Gangabai. Right to file an appeal against the adverse party.
Andhra Civil Construction versus Board of.
Yeah, Calcutta.
I'm sorry.
That's him asking.
माला किने नहीं पढ़िए दे
I know.
দেখাচ্ছি now paragraph 7. Canara Bank is a necessary party for adjudication of the dispute. Lordship has seen it, Lord, as to whether the respondent is entitled to encash the bank guarantee in question or not. Canara Bank is not a party to the arbitration agreement in question. In my judgment, the question as to whether the defendant should be restrained from invoking the bank guarantee or not cannot be referred to arbitration, having regard to the ratio of decided cases, which I will refer later. Canara Bank cannot be compelled to submit to arbitration as it is not a party to arbitration agreement. If the petitioner makes a money claim against the respondent for refund of amount collected by the respondent by encashing bank guarantee and for other consequential claims like damages after the bank guarantee is encashed, such a claim can be referred to arbitration, as the bank would not be then concerned with the dispute of this kind arising between the petitioner and respondent. To this limited extent only, arbitrator is entitled to arbitrate upon money claim arising between petitioner and the respondent. If the petitioner seeks an order of injunction restraining enforcement or encashment of bank guarantee, it would have to file a suit after impleading the bank as a party defendant in a suit. Now, this was at a time when Section 9 third party implement hadn't happened. 1992. That's why it's a suit. Today, my lord, Section 9 also it happens.
So it was not struck in mind when you filed the Section 9.
No, Section 9. Now, because it is possible to implead, my lord, a third party for enforcement of orders in Section 9, we can file. Otherwise, we used to file suits. Please see, my lord, Omega Construction, plain drafted by me, settled by Mr. Mitro. It's suit. We would always file suits.
Correct. Yes,
So,
next.
So, my lord, sum and substance of this judgment is very clear. My lord, money claim before arbitrator. If you lose, bank guarantee is invoked. Where do you get the money back? In arbitration. But injunction in court, in the presence of bank.
Yes.
Now, my lord, very quickly, please consider AIR 1987, Supreme Court, page 88.
1987? 1987?
87, Supreme Court 88, equivalent to 1987, 1 SCC, page 5. Also, my lord, what am I doing?
What point?
My lord, leave. Order 23, Rule 1. Be very brief. My lord, please see paragraph 6. Order 23, Rule 1 is discussed. Now, para 7. Milche to? Yes. Paragraph 7. The code as it now stands thus makes a distinction between abandonment and withdrawal. It provides that where plaintiff abandons the suit and withdraws from the suit without permission referred to in sub-rule 3 of Rule 1 of Order 23, he shall be precluded from instituting any fresh suit in respect of such subject matter or such part of the claim. The principle underlying Order 23 Rule 1 is that when a plaintiff once institutes a suit in a court and thereby avails of a remedy given to him under law, he cannot be permitted to institute a fresh suit in respect of the same subject matter again after abandoning the earlier suit or by withdrawing without the permission of the court to file a fresh suit. Then the Latin expression, the law confers upon a man no rights or benefits which he does not desire. Whoever waives abundance or disclaims a right will lose it. In order to prevent a litigant, this is important, Pilot, to prevent a litigant from abusing the process of the court by instituting suits again and again on the same cause of action without any good reason, the code insists that he should obtain permission of the court to file a fresh suit after establishing either of the two grounds mentioned in sub-rule 3 of Rule 1 of Order 23.
Yes.
The principle underlying the above rule is founded on public policy. but it is not the same as, my lord, section 11. Then, my lord, few lines down, rule of res judicata, that's, my lord, final decision. Then, my lord, second suit will not lie unless, my lord, you get leave. And, my lord, the reason why this issue, my lord, came up is whether this would apply. My lord, you file a 226 petition in the High Court, then can you go and file another one in the Supreme Court? Answer was no, you did not obtain leave from your High Court. My lord, please see paragraph 9. The point for consideration is whether a petitioner, after withdrawing a writ petition filed by him in the High Court under Article 226 of the Constitution, without permission to institute fresh petition, can file a fresh writ petition in the High Court under that article. Then, my lord, one sentence I am skipping, but we are of the view that the principle underlying Rule 1 of Order 23 of the court should be extended in the interests of administration of justice to cases of withdrawal of writ petition also, not on the ground of res judicata, but on the ground of public policy. It would also discourage litigant from indulging in bench hunting tactics. This is exactly what we are being accused of.
Yes.
But we have obtained leave. So this, my lord, principle doesn't stand in our way.
Yes.
In any event, there is no justifiable reason to permit a petitioner, while withdrawal of writ petition without permission to file writ petition may not bar other remedy. That's in, and then it's, my lord, deemed to be abundant if you don't obtain leave. Now, my lord, then, my lord, 2000 volume 5 SCC 458. Another, my lord, on, my lord, this aspect.
458.
2000 volume 5, yes, my lord, 458, paragraphs 13 and 17.
Which point?
My lord, this is on Order 23, Rule 1. Okay. Now, please see paragraph 13.
Yes.
My lord, 5 lines down, my lord, after paragraph 13, no doubt grant of leave envisaged in sub-rule 3 of Rule 1. Lordship has seen that, my lord, next to placetum D, is at the discretion of the court.
Yes.
But such discretion is to be exercised by the court with caution and circumspection. My lord, this is the leave which Justice Gupta gave me to come before your lordship. The legislative policy in the matter of exercise of discretion is clear from the provisions of Sub-Rule 3, in which two alternatives are provided. First, where a court is satisfied that a suit must fail by reason of some formal defect, and the other where the court is satisfied that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or a part of the claim. Clause B of Sub-Rule 3 contains the mandate to the court that it must be satisfied about the sufficiency of the grounds for allowing the plaintiff to institute a fresh suit from the same claim or part of the claim on the same cause of action. The court is to discharge the duty mandated under the provisions of the code on taking into consideration all relevant aspects of the matter, including the desirability of permitting the party to start a fresh round of litigation on the same cause of action. Then I'm omitting a sentence after which grant of leave in such a case would result in the unsuccessful plaintiff avoid decree, etc. Start on a clean slate. So grant of permission for withdrawal of a suit with leave to file a fresh suit may result in annulment of a right of the third party. That's not so relevant here. So, my lord, is a judicial order, my lord, taking into consideration all relevant factors. the leave under Rule 3.
Yes.
And the last judgment which I want to cite is, this is the latest judgment on leave, 2024, SCC Online Supreme Court 3190.
2024.
Yes. My lord, often your lordships are, my lord, confronted with a situation where a party starts a proceeding, abandons it, and goes to another proceeding. Here what had happened was, a person started, filed, my lord, a section 11, then withdrew it and filed, my lord, insolvency bankruptcy code section 7 or 9. He thought it would be quicker. 9, then, my lord, the question, he came back to file another section 11. The Supreme Court said that you can't do it because you hadn't obtained leave when you withdrew your 11. My lord, please see paragraph 41. My lord, from may I just, my lord, show your lordship from paragraph 37. I won't read it. The chapter, my lord, starts from para 36.
Yes.
My lord, 36, my lord, then 37 is order 23, rule 1.
Yes.
Then 38, difference between order 23, rule 1 and stood prior to amendment, etc. is, my lord, it's quoted. Then 39. Then, my lord, 41 is what is important. 40 also. However, if the plaintiff desires to withdraw from a suit or part with liberty to file fresh suit, same subject matter or part of claim, then he must obtain the permission of the court under sub-rule 3 of order 23, rule 1. Failure to obtain such permission would preclude the plaintiff from instituting any fresh suit in respect of such subject matter or such part of claim, and also to any cost that may be imposed. Court granting liberty may do so only upon being satisfied: first, suit suffers from formal defect, then B, sufficient grounds. Then, my lord, please see, my lord, judgments are there, what is sufficient ground, what is formal defect, etc. Now, my lord, please come to paragraph 44. The main
how much time will
5
take?
minutes, my lord. The main purpose of permitting the withdrawal of a suit and its refiling is to ensure that justice is not thwarted due to technicalities. Where permission under 23 Rule 1 is, Order 23 Rule 1 is granted, the principle of estoppel does not operate. This is important. And the principle of res judicata would not apply.
Yes.
And this, my lord, goes on up to paragraph 53. So, my lord, may I just sum up now without taking more of your lordship's time? Number one, I filed a section 9 application where I implemented the bank as a respondent in view of, my lord, in view of the judgments now which say that third party can be implemented in section 9 and court under section 9 can pass orders against third parties. So, my lord, because the jurisdiction is much widened now in the recent times, I filed a section 9 and obtained an interim order which is in my favor to the hilt, and which says that these bank guarantees can never be invoked by them. Number two, this order is continued for up till 6th of February, and the section 9 court, in accordance with the new inclusion in the section 9, that once arbitral is constituted, go to 17, matter is sent back, my lord, to the learned arbitral tribunal. We, my lord, at that juncture when this order was passed, it's sent back. We, my lord, went to the learned arbitral tribunal, filed a section 17 in terms of the dictum of the court. Now, my lord, in such a situation, by my choice, I have included the question of injunction restraining invocation of bank guarantees as a part of arbitration proceedings by my choice when I take it to section 9 and section 17. Now, when I move before the learned arbitral tribunal, upon observations of the learned arbitral tribunal, my lord, there are three issues which come up. Number one, in the absence of the bank, is it possible to obtain an order of injunction restraining invocation of bank guarantee? Answer is no, because I have shown your lordship the primary cause of action is that bank, despite knowing the fraud, is permitting. Number two, second issue is, can I bring the bank to the arbitrator? Answer is no, I cannot. And I've shown judgments for that. And number three, why then in 9? Because 9 permits it, but 17 does not. So then what do? I carve out, and under Order 23, Rule 1, I carve out a part of the suit, the part relating to injunction, restraining invocation of bank guarantee. And I pray for leave to the arbitrator to permit me to take this out to a suit. And, my lord, such leave has been granted to me. Not opposed. And it's a judicial order. After considering whether I'm entitled to it, order is granted. Order is also not challenged. Okay. So therefore, under Order 23, Rule 3, as Rule 1, Sub Rule 3, I am entitled to file a fresh suit, and it will not, my lord, operate as an estoppel against me in any manner, as per, my lord, paragraph 44 of Justice Chandrachud's last judgment. Okay. So, my lord, till now, issue of maintainability raised is, my lord, of no consequence. My lord, assertions, my lord, that this is not proper is also, my lord, not correct, because these are orders, judicial orders, which have been passed.
Thank you. That's all?
Yes. On the facts I have submitted on the last day. Even 1980. Milord, the one, Milord, I have submitted a copy also, Milord.
Hey. Sense offering for the plaintiff, sense offering for the defendant. The plaintiff has concluded his argument in connection with G1 of 2025, but due to paucity of time, learned counsel for the defendant could not argue the matter. According to Sir John, let the matter. The commercial ना? Commercial. The matter. कल कितना commercial में कितना matter?
My lord, Mr. Chaudhary won't be there. I can make my submissions. He can
No
join.
problem, Milord. I have no difficulty.
कौन सा दिन कोई फ्री है?
শেষ করতে দেবে।
Let the matter appear tomorrow at the top.
Lordship is not there.
Tomorrow.
Great. আমি আছি কালকে থাকবো আমি কালকে যাবো না
One com. J1 com.
Grateful, Milord.
At the top, huh?
Ultimately, a person must have recourse to somewhere. That is the point.
Yes. Call the list. Fixed matter नहीं है? Fixed matter बोलते?
I appear for the plaintiff in this matter, my lord.
Matter number?
42.
But I'm for the defendant.
I appear for the plaintiff. My lord, there are 3 applications pending before your lordship. GA 2, 3 and 4. 3 applications, my lord. First, GA 2 been preferred by me for commission for examining the witness. Second, they did not prefer an application, an affidavit in opposition to the commission application. They prefer an application that is GA 3. GA 4 is a demurrer application, and your lordship took up that application on the last occasion. And I have objections regarding the maintainability. So therefore, my lord, your lordship allowed me to argue on the point of maintainability. So, my lord, for this, if your lordship kindly takes the application, my affidavit in opposition, their reply, and my lord, the plaint and the written statement.
Yes.
And as I argued on the last occasion, my first objection is that
which one? GA?
GA4, my lord. GA4. GA4. Your lordship will kindly take the plaint and the written statement also.
GA4 filed by you?
Filed by the defendant for?
It is filed by us, my lord.
Yes.
It's an application under section 8.
8, referring it to the arbitration.
Yes.
So, my lord, if your lordship kindly takes the written statement first. My first objection is that, my lord, the section 8 this is a section 8 application. It was filed 20 months after filing of the written statement. And my lord, as your lordship knows, that section 8 contemplates that before filing of the first statement of defense, section 8 application has to be filed. And they have filed it admittedly, my lord, after 20 months. If your lordship kindly takes section 8 once. Section 8 of the Arbitration Conciliation Act.
Give the arbitration.
Arbitration. That's it. That's Your lordship has section 8, my lord?
Yes.
Power to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute,
yes,
then notwithstanding any judgment, decree, or order of the Supreme Court or any court refer the parties to arbitration unless he finds that prima facie no valid arbitration agreement exists.
Yes.
If your lordship kindly takes a written statement, it was filed on June 20, 2022 and affirmed on 8th June 2022.
Filed on?
June 20, 2022. It was affirmed on June 8, 2022. The written statement.
Yes.
Now, my lord takes
and this application is filed on?
This application is filed on February 22, 2024. 20 months after filing of the written statement.
Yes.
So, my first objection as to the maintainability is that this cannot be entertained because it does not, it was not filed within time, which is the mandatory requirement to be filed before the filing of the first statement of defense. Second, my lord, if your lordship comes to subsection 2 of section 8.
Yes.
The application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. Now, my lord, no original or certified copy has been annexed or filed before your lordship.
Yes.
This is a mandatory requirement, my lord, to be filed. My lord, there is nothing before your lordship to show that they have even tried to obtain the original or a certified copy. I am not going into the merits right now, but still, my lord, I will indicate your lordship that they even cannot because there is no arbitration agreement which exists between the parties. So that is the reason, my lord, where they could not obtain, but that's a mandatory requirement.
Yes.
And they did not do it. Now, my lord, on this, may I place before your lordship a recent judgment of this Honorable Court Division Bench. This is an unreported judgment, my lord.
New motion at the top.
Well, if your lordship kindly comes to para 9, I'll start placing from para 9 of the judgment, my lord.
Yes.
First, even if an application for reference to arbitration under Section 8 of the 1996 Act was to be entertained by the learned, well, before that, in this facts of the case, an application was filed after filing of the written statement. The learned court below has allowed Section 8 and also dismissed the suit. Both the things were done together, so the challenge came up. And the opinion of the court is that it cannot be done. And it was filed after the filing, so it is pat on the points. Now, my lord, para 9. First, even if an application for reference to arbitration under Section 8 of the 1996 Act was to be entertained by the learned trial judge, the suit could not have been dismissed as a whole. The matter only ought to have been referred to arbitration. Secondly, more importantly, in the present case, the defendant stroke respondent took out an application under Section 8 of the 1996 Act only after filing of the written statement, thereby defying the mandate of Section 8 of the 1996 Act itself. Thereafter, my lord, I have just placed Section 8. It has been set out in Section 11, paragraph 11. May I skip it and go to paragraph 12? A bare perusal of the section clearly shows that a judicial authority can only refer the matter to arbitration in the view of the existence of an arbitration agreement clause if the party seeking such reference applies for such reference not later than the date of submitting his first written statement on the substance of the dispute. The first statement on the substance of the dispute in case of a civil suit is, without doubt, the written statement filed by the defendant. It is an admitted position that in the present case, the application under Section 8 of the 1996 Act was filed after the filing of the written statement, and as such, the provision of Section 8 of the 1996 Act could not have been invoked by the learned civil judge. Another limb of argument of the defendant, respondent, is that in paragraph 12 of the written statement, the defendant pointed out that the civil court has no jurisdiction to entertain the suit in the view of clause 22 of the agreement dated such and such, and as such, the same should be dismissed. If it is argued by the respondent that clause 22 was an arbitration clause, and as such, paragraph 12 of the written statement should be construed to come within the purview of an objection taken by Section 8 of the 1996 Act. With utmost respect, we are unable to express our agreement with the view taken by the single judge of the Delhi High Court in this concern. It is specifically held by the Supreme Court in the case of, there are citations given, that an application on Section 8 of the 96 Act has to be filed before the filing of the first statement on the substance of the dispute. Thus, the view taken by the Delhi High Court is contrary to such proposition. Moreover, on the other aspect as to whether an objection in the written statement as to the jurisdiction of the court can be construed to be an application under Section 8 of the 1996 Act, we also are unable to agree with the arguments of the respondent. Here I pause a bit. They have only taken the ground that it is not maintainable. In the written statement, they did not have referred to any arbitration clause. But my lord, even if they have referred, a mere objection as to the maintainability cannot be an objection under Section 8. This is absolutely clear now. There is a gulf of difference between an objection that the learned court does not have jurisdiction to entertain a suit at all, and that the suit should be dismissed on such ground, and an objection that the subject matter of a civil suit, being also the subject matter of an arbitration agreement, ought to be referred to arbitration. Section 8 of the 1996 Act contemplates a reference to the arbitration of a dispute regarding which there is an arbitration clause and does not operate as a bar to the civil court's jurisdiction as such. Even if a reference is made to the arbitration, the civil court does not lose the subject jurisdiction. It is only the operation of Section 8 of the 1996 Act that the civil court has to refer the matter to arbitration. Moreover, the provision of Section 8 of the 1996 Act contemplates a bar, if at all, which can be waived by the parties. A bar which can be waived by the parties is not an absolute bar on the jurisdiction of the civil court, coming within the connotation of express or implied bar as contemplated in Section 9 of the Code of Civil Procedure. In the in the event no application of a reference of arbitration in section 8 is made by either party, the civil court may very well entertain the suit and proceed with the adjudication of the same on merits in accordance with law. Here, my lord, since it was not made before the filing of reinstatement, it has to be considered as not made because it's not maintainable. Hence, we do not find that the existence of an arbitration clause in the concerned agreement between the parties operates per se as a bar to the jurisdiction of the civil court. Thus, the objection taken in paragraph number 12 of the written statement in the present case regarding the civil court not having jurisdiction even to entertain the suit and seeking dismissal of the suit of such ground cannot be a bar with an application seeking reference to the arbitration under section 8 of the 1996. The two operate at different levels. Hence, we cannot under any stretch of imagination equate such an objection taken in the written statement as to the jurisdiction seeking dismissal of the suit with an application to refer the matter to arbitration. Thus, the said point we humbly express our disagreement with the view taken by the learned single judge of the Delhi High Court and in the cited judgment. In the view of such discussions, the learned trial judge committed a patent error of law on both counts. First, the suit could not have been dismissed under Section 8 of the 1996 Act. Secondly, Section 8 application having not been filed before or even simultaneously with the written statement of the defendant could not have been entertained at all by the learned trial judge. Accordingly, my lord, the appeal was allowed and it was directed that a trial be proceeded with. My lord, if your lordship kindly takes a written statement now. Written statement
What do you want to show from the
It's paragraph 7 of the written statement I want to show first. The only objection as to jurisdiction, the Honorable Court does not have jurisdiction to try and entertain the present suit since the entire cause of action has arisen outside the jurisdiction of this Honorable Court. So they have raised the maintainability on a particular ground on the jurisdiction, not on the arbitration clause. So there is not a whisper in the written statement regarding the arbitration clause, and the written statement was filed much before. My lord, as to the maintainability, these are my points, but my lord, I'm not going to, because if your lordship is in my favor according in the point of maintainability, I need not go into the merits. If they
yes.
Only one thing, my lord, I'll show. Only one thing.
What?
They are actually relying on two agreements. If your lordship kindly takes their application, paragraph 12.
Paragraph 12 of this application?
Of this application, man.
Yes.
Written statement. Paragraph 16. So, my lord, from their application, what they are seeking, paragraph 12. In the circumstances, defendants submit that the dispute between the parties arising of the instrument dated August 11, 2014, and the agreement for sale dated January 9, 2015. So,
yes.
These two agreements they are relying on
yes.
as to a property called Aqua Golf property. Yes. Your lordship kindly notes Aqua Golf property because that is important. Now, your lordship kindly takes my plaint first.
Aqua Golf, where you got it?
The paragraph 11, just before paragraph 12, they have only said
Aqua
they have
Golf.
used the abbreviation Aqua Golf property. It's correct. Aqua Golf property is correct, my lord. Page 13.
Yes.
First paragraph, Aqua Golf. So they are saying that these two agreements have got arbitration clauses.
Yes.
First, my lord, my contention is that August 11, 2014 is an agreement which is not in dispute. Why, my lord? If your lordship kindly comes to Page 105 of the plaint. I have annexed.
You filed this suit on the basis of which agreement?
This is, my lord, I'll tell you what it is suit for. It is for refund of money for purchase consideration paid. Not based on any agreement, my lord. We have paid the purchase consideration and they did not hand over the property within time.
No, purchase consideration, there is no agreement.
It's an oral agreement, my lord. Okay. Absolutely oral agreement. I'll show that to your lordship. There are two properties. Second property is not in dispute. They are not even asking for it. There was no agreement. The second agreement was a draft agreement. I'll show that to you. And they have agreed to that. If your lordship kindly takes the written statement, first let me show what they have pleaded regarding these agreements.
No, let me see with regard to the first point. Yes, Mr. Banerjee, what is your point?
Well, for this
Admittedly, you
point,
filed after the.
for this point, I will definitely address your lordship, but I will not be in a position to complete it.
No,
today.
admittedly, you have filed the after the written
Yes,
statement.
I have filed this application, my lord, after. I know it's a hurdle, very difficult to cross because of certain recent precedents. My argument before your lordship would be that the scheme of the 1996 Act requires parties to be referred to arbitration. And that scheme of the 1996 Act has, my lord, even when it was amended in 2015, the scheme and purport doesn't change. Of course, there is an expression used under Section 8, and that is the hurdle which I want to, my lord, cross. Whether the point comes, my lord, whether I have waived or acquiesced my right to pursue arbitration, despite the fact that the subject matter for dispute before your lordship in the suit has matters which are referable for arbitration.
No, once you, because
now, my lord,
this
it
court
comes.
is also some binding.
Yes,
The
yes.
later judgment of the appellate court. Now
Yes.
that has categorically held that you
Yes,
cannot.
so, my lord, I will have to show your lordship that, of course, through certain law commission reports as well, why this can be changed, why a view from your lordship can be changed. Because
how this court can now it can be changed after the order of the division bench.
you know, that I will also address. Firstly, in the facts of this case, of course, there is a written statement filed, and the Section 8 applications comes after that.
Correct.
Kindly consider the situation that if your lordship today is countenanced with an application which is for recalling of the order and recalling of the written statement, what happens in that situation? I give a reason that this written statement was filed by omitting certain provisions of law. Maybe I come up with an affidavit from the advocate who has done it. Before your lordship, at that point in time, will lie only two substances. A, to determine, A, has this particular defendant waived and acquiesced the crying call for referring the matter to arbitration? Because it is not that he hasn't made an application. I'm not relying on one fleeting statement of the written statement, and my submissions before your lordship is backed by a Section 8 application. It is only that the Section 8 application has been filed after the written statement is filed, which is to be considered as the first statement of defense. If I can show your lordship that that first statement of defense is defective by itself, before your lordship, if I can demonstrate sufficient equitable reasons and cause, maybe your lordship can consider differently. So the issue which comes over here, my lord, is whether a party has acquiesced and waived that right, because the scheme of Arbitration and Conciliation Act is expeditious and cost-effective redressal of disputes, and that is being promoted. It is not and minimal intervention of other judicial civil forum. So before your lordship, if I can show that this may not be the first statement of defense because this is a defective one. That first word is used in the statute. But if I can show that this is a defective one, and then argue on the merit and say that there are not just one, but multiple agreements between the parties where ultimately dispute arose and they are not willing to take the property which the developer proposes, disputes are there. There is no doubt that there is no dispute. Otherwise, the suit would not have been filed. So disputes are there. If I can show, because it fell from your lordship, what is the judgment, what is the agreement from which you have come before the court? It can't be that there will not be any agreement when there is a purchase and sale of flat or flats going on. There is, of course. So contrary to that, there is a verbal agreement. Matter of proof, of course. But dispute is there. So if I can show your lordship that the genesis of this particular transaction came up from a agreement, and that agreement has an arbitration clause. That agreement is continued even subsequently, which also has an arbitration clause. And even finally, there is another document which they allege was not signed. That also has an arbitration clause. Execution has to be determined by the arbitral court or by the arbitrator. So all these things, in merit, I may have a good case. Contrary to that, it has to be determined whether I had given up my right or not, whether I had waived my right or not. And if I have waived it, such waiver will have to be conscious. That is the import and significance of the word first.
No, it is not said that waiver. It is said that once he heard the defense.
Millard will read it with section 4 of the Arbitration Conciliation Act, both being under part 1. Section 4 has certain regards with respect to the right of a party, whether he can challenge that agreement or any arbitration clauses at a subsequent stage or at a proper stage. Section 4 kindly takes up. It has to be read with 8, because 8, the embargo is waiver. Waiver of right to object. Today I am objecting to the suit. A party who knows that any provision of this part from which the parties may derogate or any requirement under the arbitration agreement has not been complied and yet proceeds with arbitration without stating his objection to such compliance without undue delay or if a time limit is provided for stating that objection within the period of time shall be deemed to have waived his right to so object. Now, Millard kindly takes a flip side position of this, which is exactly a suit filed. There may be an arbitration agreement. If the defendant doesn't come and object, then it is considered as waiver of right. And if there is a first statement of defense, then the defendant establishes that he has waived and acquiesced his right.
Correct.
And has proceeded.
Only come to the B. Any requirement under the arbitration agreement has not been complied with, yet proceeds with the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection with that period of time shall be deemed to have been waived his right.
Yes. So, this is kindly considers the flip side of this particular provision. I'm not saying that kindly 4 will apply in this particular case. What I am on is that when your lordship is reading section 8, the idea is that to inquire and ascertain whether the defendant has actually waived his right to arbitrate.
The first the court has to see the
arbitration agreement exists or not. That's the first trigger.
First, we have to see the section 8 whether you have complied with the section 8 or not.
Correct.
Complied with.
Yes.
In the section 8, then the conditions come. What are the conditions in the section 8? First, the condition is that you have to file a section 8 before disclose of your defense.
First statement of defense. Yes, Millard, I'm on section.
Defense. Correct. First statement of defense. Subsequently, it comes whether original is filed or not filed, or whether it contains the arbitration.
Whether original filed or not filed, no document is disputed. These are documents from the plaintiff itself.
That is different. No,
These are documents from the plaintiff.
Disputing a document is a matter of the suit. It doesn't.
No, that is I am telling the. So these are the conditions. So now, if you wanted to go to the section 4 waiver, the first you have to comply with the provisions of this section 8. It is not immediately okay. By mistake, it has filed the written statement. Immediately, you file the section 8 on the very day or second day or whatever. You have waited for the just to.
Yes, the client has waited. In the meantime, we filed an application for extension of time to file written statement. We've given the reasons. There is a change of advocate. I know I have to take steps to remedy this statutory bar.
And here also it is not provided what is to be done. Once it has been mandated, provision has been given, and that has been upheld by even Supreme Court is also there. If you are not disclose your section 8 and you file
the original, if that is what the
written statement. Once you disclose the written statement, how you can say the section 8?
I can only say that the written statement was not my statement of defense, and that has some lacuna. Kindly allow me to come back on this, my lord, because I also need to show your lordship certain things which I would try. I understand what has fallen from preliminary. Very
Because
difficult.
It can
Very
be.
difficult.
What you have taken, that can be a point of law. Before filing of the Section 8 application, you file an
Yes,
application for declaring that the written statement is not in
No, no.
accordance with law. You wanted to
Quotient of diligence is
Written statement.
highly against
Cannot.
me. Quotient of
Absolutely
no, no,
according.
I've seen it. Quotient of diligence is against me.
My lord, based on this written statement, they have disclosed documents. They have taken steps, and now are saying that they're tracking. No, one paragraph before they are saying that there's arbitration clause. One paragraph. They have themselves said there is no arbitration clause. I'll tell you, lordship. Lordship, kindly take the written statement once.
So, my lord, as it appears that what I am submitting before your lordship, the client has become wiser, and it happens. It is not unheard in series of litigations. It happens, and we do have an option to amend written statements. That is permissible under law. The only point is that whether, my lord, I'm on basic principles, my lord. Yes, it is a basic principle that if there is an arbitration clause, your lordship will refer it. That's basic. The second basic principle is if there is any wrong thing stated in a pleading, the courts allow amendments for it to be rectified without even prior to addressing jurisdictional issues. The third point is that I have filed a written statement. I don't have a counterclaim, at least in the written statement which has been filed.
Correct.
So, if I today want to amend my written statement, then, and there is no judgment upon admission application, then and try to cure a defect, then the advantage so-called which has been created in behalf of the plaintiff may not be turned down on my request.
By way of amendment, you cannot say that the written statement treated after the application section 8.
Correct. So, my lord, as I said, that there has been, my lord, kindly see the name of the party, Green Tech ITCs is not a lawyer's firm. I'm making a certain submission.
ITC, but you keep it in mind, ITC.
IT City, not ITC. ITC would have been different.
No litigants are lawyers' firm.
Correct.
It's a
Correct.
amazing
So
argument.
here, if I
Banerjee.
difficult.
I
started.
I am passing an order.
Only
Please,
one
please,
thing.
you argue
Only one thing, my lord.
before the appellate authority get the law settled.
Only one thing, my lord, before your lordship.
My lord has given orders which are very bold.
Very bold.
Even with respect to, my lord, the latest one which your lordship referred the matter.
But my lord has given orders which are absolutely legal. I do not know what he's insisting
so
about.
kindly give me one opportunity where I can come back before your lordship.
My lord,
Consider
I am
this
objecting
judgment
to this, my lord.
and make my
February
submission.
2023, 1 year, my suit gets related. Only one thing, my lord.
Next week.
They are saying.
Kindly
I
allow me
can
to
give.
come back.
See, regarding giving the time, but what purpose? The
Difficult,
law is
difficult.
settled.
But I say
One more thing, my lord. They are saying.
Cannot be unsettled.
My lord, they are saying that they did
Let
not.
me give an attempt, my lord. The
Cannot
law
be-
was also settled, my lord, with respect to 106 notices and commercial dispute.
No, that's
I got a judgment myself from your lord, and then reference. So, my lord, it is evolving. It is perhaps the most dynamic, my lord, discipline. Lordship will give me one opportunity anytime next week, whenever it's commensurate to your
The
lordship.
next week, my learned friend Mr. Banerjee will come and show your lordship that Section 8 can be filed after written statement. Amazing argument, my lord. Your lordship kindly takes the GA filed by them, GA3. They are saying they did not proceed with the suit. I'll show GA3. The lordship will kindly take the prayers of GA3.
okay. Come.
Only GA3, the prayers, my lord.
I hope I'll get one more day's life.
My lord, I'll show the orders. How they delayed the suit.
Granted to examine
No, GA, that's GA2, my lord. GA3. GA3 is there.
GA3 is there.
GA3
What is
to
the prayer?
an order
Option application.
be passed directing the plaintiff to make discover of documents in their possession. That's what they're praying. Proceeding with the suit, my lord.
Issues have not been framed.
Will you Rashmi kindly see the prayer in the notice of motion? So they have this, and also, in fact, if a lordship kindly sees, may I just please, because it's a copy, the same advocate on record. He's saying advocate record change this and that.
That is not the ground.
They have discovered documents,
They
my lord.
may say,
My lord,
they may
my lord, they have discovered documents. An inspection has been completed. They have proceeded with the suit. Now they are saying that written statement is defective, this, that. In the written statement, they have admitted there is no arbitration agreement.
And Mr. Banerjee is there.
There's an instruction.
Not instruction. He want to create a law. this is the suit whether the time is to be given.
No, my lord,
Just
from
one option.
February, no, my lord, from February to,
I will not prolong further.
November, if your lordship takes your lordship's own order, November.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Full stop. The defendant has filed an application being GA
4.
GA Com 4 of 2024, spring under Section 8 of the Arbitration and Conciliation Act, under Section 8 of the Arbitration and Conciliation Act 1996, praying for referring the matter to the arbitrator, referring the parties to the arbitration. Full stop. Learned counsel for the plaintiff has raised plenary objection with regard to the maintainment of the application filed by the defendant on the ground that the defendant has filed the said application after the period of 20 months from filing of the written statement. Filing of the written statement. Full stop. The full stop. It is also argued that in the written statement, the plaintiff has, and the defendant has also only mentioned with regard, only simply mentioned that the suit is not maintainable.
For the jurisdiction.
Not maintainable.
For the want of jurisdiction.
For the want of jurisdiction. But the defendant has not mentioned about any provisions of Section 8 of the Arbitration and Conciliation Act in the written statement. Full stop. Counsel for the plaintiff has concluded his argument with regard to the maintainability. Police counsel for the defendant and plaintiff has concluded his argument. Conclude. With regard to the maintainability of the application, police counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Accordingly, the case is adjourned. Let the matter appear on 11th February.
My lord, only one thing. In the written statement, they have not even pleaded or even spoken about the arbitration.
That already did.
11th February, my
11th February is not a suitable day for my learned advocate on record. She's becoming unsuitable somewhere else for life.
The only thing, my lord, only my lord, from last February.
Non-commercial. Non-commercial.
Let it remain in the list. It will get called.
No, my lord. Let it be fixed. Only thing is, my lord, one thing I want to point out from last February, this suit is being stalled because of this application.
I will dispose. That's why let the matter appear. Then 19th February.
Can there be a shorter date, my lord?
Not it is.
He
is having some problem. Personal ground.
My junior instructing that she's getting married on the 12th, not on the 11th. So.
Oh yes. You'll remember for Miss Chaudhary.
They're that she should come on 11th.
They are batchmates, and he has attended my chamber, Mr. Banerjee. So well, only one thing, my lord. Can it be before 10th? Any date before.
Before 10th, the first week is totally vacant. Third and fourth is leave.
Any day, I don't think it will take much time.
Too much of bargain on this date. Let it be that date. We will attend.
Their prayer should have been adjournment in any case.
Okay, 5th.
Grateful, my lord. Fifth. Grateful.
Obliged.
But any time, my lord?
Time.
And then in that case, it will not get.
Come on.
1 p.m. man. 1 p.m. No.
Part. Yes. Next.
Grateful.
Fixed matter. Fixed matter.
I am for the defendants, Miller. Yes. I had commenced my cross-examination on the last occasion, and today I am to continue.
Witness action?
Yes, Miller.
उसको बोला पानी डालो बोला यार. Your names.
Already witness is already on.
Kailash Nevatia.
Further cross, huh? Further cause resume.
Peace. Kailash Nevatia.
Last दिन questions शुरू दिया होंगे ना?
Trading बोलबो?
Sir, what was your age?
Age.
Age. What? I'll go slow. What was your age in or about 1976?
1976. I have to calculate. 1953 my birth. 29th May 53.
It is slow.
29th May 1953.
Is my birth
date.
Birth date.
So I take it that in or about 1976, 1976 to 1979, your age would have been ranging from 24 years to 26 years.
It may be, sir.
It may be.
But yeah, at that point in time, which is around 1976 to about 1979, were you professionally engaged
Yes, my
for
lord.
earning money?
Yes, my lord.
Can you please tell this honorable court how much money did you earn in or about a year during that point in time? That is 1976 to 1979.
Actually, I don't know the actual figure, but
Figure.
I have to check up. I'll let you know.
What will you check and let this honorable court know?
I'll check my IT file.
I will check my IT file, income tax file.
Can I take it that you have your income tax return files for the assessment years 1975-76 till 1979-1980 with you?
It was with me, sir, but due to
With me, due to
certain demolition of the premises, certain papers has been destroyed.
demolition of the premises, certain papers
Has been
have
destroyed.
been destroyed.
Demolition of which premises are you referring to?
76 Bentic Street. 6 Bentic Street. This should premises.
Bentinck.
Bentinck. B-E-N-T-I-N-C.
Bentic Street.
Bentic Street.
Did you order such demolition for the building?
No, the building is gradually.
Slow, you have to be slow, sir, please.
The building is very old. Building is very old, and gradually it is in dilapidated condition. Gradually it is broken part by part.
Can you produce your income tax returns, which has been referred earlier before this honorable court on the next occasion?
If I find, I must produce it.
I must produce it.
If I find, I must produce it.
Do you recall how much money you had paid for purchasing the property at Bentinck Street? For purchasing the proportionate share of the property at Bentinck Street? Madam, please do this correction. Thank you so much.
First, I purchased 1/6 share in the year of 1977.
1/6 share.
1/6
share in the year.
Please repeat the question. I was asking for the money. How much you spent?
How much money you have spent for purchase of the
I'm
property?
coming to that point, my lord.
Okay.
Well,
1/6 share
1977 most probably, for 30,000. For 30,000. And subsequently, in the year 1980, I have purchased a half share for 1,25,000. 25,000.
Do you want to say that this aggregate amount of rupees 1,55,000 allegedly used for purchasing your proportionate shares in the Benting Street property was from your own income?
Yes, my lord.
So do I take it that from your income tax returns, it would be clear that you had sufficient income to purchase these properties by spending the aggregate amount of rupees 1,55,000?
Yes, my lord.
Mr. Nivetia, what did your father do as a profession?
My father was the auction purchaser. Later on, he was being ill of health.
Ill of health.
Will I be right in saying that he had substantial affection towards you and the rest of his sons?
I don't know.
Do you disagree that he was not affectionate towards you?
He was normal person as a father.
Will I be right in saying that your father was a wealthy man at that material point in time?
He was so-so person, not wealthy. So-so person.
He was so-so person, not so wealthy.
Did your father help you in purchasing the Benting Street property?
No, sir.
Did your father provide you with the fund?
Sorry, sir.
Let me complete the question. Provide you with the funds for purchasing the Benting Street property?
No, sir.
When did your father die? May you let us know?
In 1986. 1986.
Did your father make a will or he died without executing a will?
Yes, he has made a will and given his entire estate to my mother.
And had given given his entire estate to
My mother, Srimati Tara Nivetia.
Srimati Tara Nivetia.
Movables and immovables, both.
So the name of the estate, as you have referred, would be Tara Nivetia Estate. Am I not right?
What for?
Just refer to the earlier answer. You said use the word estate. That's why.
Question to follow.
আমি বুঝতে পারিনি।
এর আগের উত্তরটা একটু পড়ে দিন। Just read out the answer which he had given to the last question. The question is the name of this estate known as Tara Nivetia Estate?
Previously, it was Devur Nivetia Estate. Previously, it was Devukaran Nivetia. Devukaran Nivetia Estate. left my father. Left my father.
Left by my father.
So after your father passed away, the name of the estate is Tara Nivetia Estate. Am I correct?
It may be. It is a matter of record.
Can you tell this honorable court when did the demolition of the Benton Street property happen?
So it's a very old building, about 200 years old. And gradually it's made of lime and surkey. Lime and surkey, Lime, lime and surkey.
SURKY.
And part by part it was demolished itself and also endangering neighbors. Endangering neighbors.
Endangering neighbors.
How do you think to manage this alleged dilapidated building now?
Complete.
Yes.
May I speak?
Yes.
This building is so in dilapidated condition. The tenants has moved an application before the Honorable High Court.
Have moved an application before the
Movable High Court.
Honorable High Court.
And Justice Amrita Sinha passed an order upon the KMC people.
Justice
Has
Amrita
passed-
Sinha passed an order directing the KMC people
to let us know their decision before 14th August
14th August
2023 to demolish the dangerous position
to
demolish the dangerous portion
portion
of the building.
of the building. And the KMC people has instructed to demolish first and second floor immediately.
And the KMC persons have instructed to demolish the first and second floor immediately of the building.
Premises.
Are you occupying any portion?
Yes.
Just sir, I of this dilapidated building. That's my question. Are you occupying any portion of this dilapidated building?
Yes, my lord.
Can you please tell this honorable court which part of this Benting Street property is occupied by you?
At present, only in ground floor, I have got 3 and 4 rooms.
Ground floor about 3 and 4
4
rooms.
rooms.
Yes.
And rest of the ground floor is occupied by the tenants. Different tenants.
By different tenants.
How many more floors does this Benting Street property have?
Main building has no more floor.
Main building is not having
no
any floor.
Any floor. Annex building has only one room on the floor, which is one room only.
Do you want to say that there is only one room which you call as the annex building?
Yes.
Who is occupying that one room, alleged one room of the annex building?
Chandrasekhar Nevetia.
Chandrasekhar Nevetia.
So in the entire Benting Street property, according to you, presently you are occupying 3 to 4 rooms
in the ground floor.
in the ground. Yes, sir. Your answer?
Yes, in the ground floor.
Yes, in the ground floor. And how many tenants are there in the Benting Street property?
About 22.
So there must be about 22 separate rooms over and above your 4 rooms
Of course.
in the Benting Street property.
Of course.
How much rent, aggregate rent, do you collect out of these 22 tenants?
I don't
If you can recall and say.
At present, I can recall and say right now.
I cannot recall and say right now.
Can you kindly inform how much rent you receive from the 22 tenants of the Benting Street property before this honorable court on the next day?
Let me check up, I must know.
I will check up and then I will let the court know.
What will you check?
My records.
My
records.
records.
What do you mean by quotation? My records, unquote. What do you mean by my records?
What is the rent receipt? Whatever I issue, I have to see
Rent receipts, whatever I issue.
issue. I have to go through that.
I will go through that.
Out of which some tenants are paying, some are not paying.
Out of which some tenants are paying and some
Some
are not
paying.
Are you maintaining any record or accounts of those tenants who are paying and those who are not paying?
Whatever paying, I have got the receipt. But not paying, what should I say? They are there.
Are the defendants also tenants of the Benting Street property?
No.
Was your mother ever a tenant of the Benting Street property?
Mother was the tenant. Was the tenant.
Mother was the tenant.
Mother was the monthly tenant.
Monthly tenant.
What was the purpose for which she used such monthly tenancy?
He has taken the premises and subletted portion.
He had taken a premises and sublet a portion. Sublet a portion.
Portions, different localities. Yeah.
Portion or portions to different people.
And you will agree with me that when did she become a monthly tenant of this premises? If you
1956.
And in 1956, you were about 3 years old. Am I right?
Whatever is there.
Your mother had the right to sublet the premises to third parties, as was her original agreement with the landlord. Will you be in a position to deny this statement?
Complete?
Yes.
My mother was a mere monthly tenant with the power to sublet.
With the power to sublet.
To sublet.
To one person, different person.
To one person to different person.
Second, she was asked to maintain the property and to pay the taxes.
Secondly, she was asked to maintain the property.
And pay the taxes.
And pay the taxes.
When did your mother pass away?
2006.
Did your mother make any will
Yes, that is
before
pending
she
in the
had
court.
passed away?
Yes, that is there and pending in the Honorable Court.
Yes, that is pending before the Honorable Court.
Why is it pending before the Honorable
I have objected.
I have
I have objected for the. I have objected for.
Who has come up before the Honorable Court for grant of probate of the will of your mother?
Complete.
Yes.
My mother in the said alleged will.
in the said
Alleged will, my mother has appointed 4 executors, that is 3 sons and 1 her daughter, and 1 daughter.
one daughter.
And in the court, my brother Shiv Kumar Nivetia
And in the court, my brother Shiv Kumar Nivetia
and sister Anju Nivetia, Anju, A-N-J-U,
Nivetia.
Anju Nivetia have applied for the probate of the will.
So will I be correct in saying that? Please, Eric. If your mother.
Just a minute. Just a minute.
Yes. Sorry. You was there.
Thank you. So,
Yes, yes. Take water.
He can also take a chair if he wants to.
no.
I saw him in the corridor. He had come at before 2 o'clock. I told him to sit.
My lord, I'm living far, Bangalore Avenue. It takes 1 hour more. That's why I try to come in advance. Thank you, sir.
You're comfortable?
Yes, sir. Thank you.
Will I be right if I say that according to you, unless probate of the will of your mother is granted, no portion of her movable or immovable properties can be claimed by the beneficiaries?
I'm not aware of that.
Is it ask that's the thing?
I am not aware of that.
You're not aware. Assuming, but not admitting that a will did not exist. Assuming a will did not exist. Who would be the heirs and legal representatives of your mother?
For what? There are so many things.
Property. With respect to devolution of properties?
Properties.
And heritable rights?
In properties, there are ownership properties and tenancies. Which property do you mean?
I said meant both.
Can't do both. Ask separately.
Okay.
No, sir. So please, not to ask the question.
I don't want to. Last day's confrontation, I don't want to.
Not to put the question. His simple question is that if the will, suppose there will be no will, and the property mentioned, the assets mentioned in the will be developed to whom? If there will be no.
My lord, if it is ownership property, that will go to the legal heirs.
Okay, record. If it is the ownership property, it will go to the legal heirs.
If the tenancy property.
If the tenancy property.
That will go in different way.
That will go in different way.
But then can't be bequeathed. Monthly tenancy can't be bequeathed.
But monthly tenancy cannot be bequeathed.
If it is bequeathed, tenancy goes.
If it is
If it is bequeathed, tenancies go.
কবে মারা গেছেন মা বলতেন
2006
বলেছে।
Yes.
If I say that on and from 2006, that is after your mother passed away, her tenancy has her right of tenancy has devolved in a limited manner to her 3 sons and 1 daughter. Will you disagree with me?
It can't be.
I do not agree.
The portion which your mother used to occupy at the Benting Street property, does it still survive the demolition?
Mother did not occupy single inch there.
My mother did not occupy a single inch in that property.
Do you receive any rent from your brothers with respect to portions occupied by them at the Benting Street property?
How could I? They are the co-owner. How they will pay me the rent?
They are the co-owner. How I can get the rent from them?
Have they ever approached you to pay rent?
I don't know, sir. I've never heard.
Not no, I have never. No, I have never heard.
I put it to you that the defendants are also tenants with respect to certain rooms at the Benting Street property.
You may agree, you may disagree, sir.
Yes, yeah. No,
I do not agree.
I do not agree.
I put it to you that such right of tenancy of your brothers have been derived out of the tenancy which your mother had with respect to the Benting Street property.
Completed?
Yes.
First of all, mother cannot create any fresh tenancy. She was a defaulter.
First of all, mother cannot create tenancy as she was defaulter.
Never paid rent to me.
Never paid rent to me.
I am being the 2/3 owner of the premises.
I being 2/3 owner of the premises.
Now, what is the next question, sir?
Why didn't you initiate eviction proceedings against your mother?
It is not feasible. Again, you are.
Why don't you
Why
initiate?
didn't eviction proceedings against your mother?
It is not feasible, my lord. I cannot proceed against my mother.
It is not feasible for me to file suit against my mother.
So you allowed your mother to exercise her right as a monthly tenant in the Benting Street property by waiving any claim as a landlord against her?
I do not agree.
You accepted and you were fine with her not paying rent. Am I right?
হয়েছে আপনার
হ্যাঁ।
স্যার অ্যাজ আই টোল্ড ইউ একটাই কোশ্চেন বাবা জিজ্ঞেস করে কি লাভ মায়ের আগেনস্ট আমি কিছু প্রসিড করতে পারি না
I cannot proceed against my mother.
When your brothers inherited the limited right of monthly tenancy, They also attempted to pay rent to you. Do you agree?
I do not agree. It is a false. Again, আমার রাগ হয়ে যাচ্ছে।
Please keep quiet. It is the duty of the advocate to put the question. Please keep quiet and give answer.
Keep your calm, sir.
Please calm down.
I do
Yes,
not
my lord.
agree,
I'm
and
sorry,
it is
my lord.
false.
I apologize, sir.
Keep your calm.
What are you doing with the 3 or 4 rooms which you claim to be in possession at the Benting
My
Street
office
property?
there, my business is there.
My office is there, my business is there.
Nowadays, due to my health, I cannot do my business. Previously, I tender government with government.
Due to my ill health, I cannot do my business previously.
Previously, I used to
go office and have tender contracts with the government, Chitanjan locomotive works.
Previously, I used to go to my
office and participate in the tender.
The tenders with CLW, Chitanjan locomotive works,
CLW
Tata Group, and local people.
and local people.
So I take it that you are a busy person
Of
and
course.
had other means of income to cater to.
So you are the busy person. You are had a good income.
Yes, of course. That's why I'm not claiming any amount from my mother.
That's why I am not claiming any amount from witness volunteers.
From my mother.
I put it to you that you did not have sufficient time to look into the matters which were happening with respect to the Benting Street property because you were otherwise busy.
I do not agree, sir.
I put it to you that your mother, during her lifetime, had inducted your brothers, that is the defendants herein.
I have replied already, my lord.
As tenants of the said of portions of the Benting Street property.
You have completed?
Are you aware of this?
Are you completed?
Yes.
My mother was a defaulter, I told you, and she has no more power to induct any tenant to the premises. Whatever she had inducted, that is long before.
Long ago.
She was a defaulter. How could he induct the new tenants?
Was a defaulter. How could
she induct new tenants?
She induct new tenants. Question mark.
Did any competent authority adjudicate that your mother was a defaulter or with respect to her monthly tenancy?
I am the adjudicator authority. I am the owner.
I am the adjudicator authority.
I am the adjudicating authority as I am the owner.
Of the 2/3 divided share.
Of the 2/3.
He has not paid me any rent for 40 years.
Of the 2/3 share of the property, as he has not paid any rent to me.
And derived from the subtenants.
40 years. Derived from?
Subtenants rent regularly. কি বলছেন
Last year.
উনি রিরাইজ করেছেন সাবটেন্টের কাছে ভাড়া She was realizing the rents
Realizing the rents
from the subtenants.
from the subtenants.
Did your mother pay rent to you even for once?
I told you, whatever she has not paid me any rent. Whatever receipts she had procured for me for income tax purpose.
Receipts she had.
She has not paid any rent to me. Whatever the receipt procured from me only for her income tax purposes.
So you will agree that there are receipts with respect to her monthly tenancy issued by you for whatever purpose.
It may be, whatever it is a matter of the court.
It may be. It is matter of records.
No, it is maybe whatever it is, it is matter of records.
But it is matter of
You have no, Chair. When did you file this plaint? Do you remember? Before this honorable court?
This partition suit
Yes.
in 1923.
2020.
2023.
At that point in time, did any demolition of the Benting Street property take place?
Complete.
Yes, sir.
Just I told you, KMC has issued to demolish
Did
the
any demolition of the Benting Street property take place?
KMC has issued the order to demolish the first and second floor immediately
demolish the first and second floor immediately
of the main building.
of the main building.
Can you tell this honorable court about how many rooms are there on the ground floor of the Benting Street property?
How many times I will say, my lord?
One last time, sir. Please.
I think this is repetitive.
Yes, already
This is
stated.
not-
No, he has not said this.
It's ridiculous.
Brother, there is a
2021
I can confront with a lot of things.
2021
No, you can't
tenants
repeat.
are
No,
there.
22 tenants.
20
Oh, yes, he has said. Ground floor, he has said. I'm so sorry.
20
Ground floor, he has said.
No,
Yes,
no,
brother.
this is the second time. Earlier also he stated that.
No, ground floor, he has said. I'll withdraw this question. Please withdraw it.
Give.
I put it to you that you do not occupy any room on the ground floor of the Benting Street property. It's a suggestion. You may agree or disagree.
I do not agree, my lord.
How many rooms were, or how many rooms are there on the first floor of the Benting Street property?
I told you, my lord.
Please tell once again, sir.
This is repetitive.
No, he has filed and affirmed a suit.
This is repetitive.
The witness
No,
knows
he has
in
also
English language
stated-
is very well known
He
to
has
him.
also stated that there is only one room in this
Yes.
building.
Yes. Then why has the plaintiff not amended the plaint?
Whatever it may be. But
Whatever
already
that
it's
is
not-
here, my lord, lies the question.
See,
Here, my lord, in a partition suit,
correct.
there are two premises, Benting Street, Lenin Sharoni.
Correct.
There are, my lord, many rooms which the plaintiff says exists. There are, my lord, he also says that demolition has taken place. That is post facto to the suit being filed. And there is also Lenin Sharoni property. Both properties are old. Question arises, and this is a very moot point of dispute, my lord. My lord, the witness can be discharged. I wanted to address this point. There's only few minutes. I want to make this submission. He can remain in the courtroom. I have no problem.
Okay, you sit.
My complete
For the day.
For the day. Again you have to come.
Again.
How much time you will take for
I will take some. I will.
No,
No, my lord, as I was submitting, my lord,
Please you sit.
with
please.
respect to the number of rooms and partition suit, my lord, plaintiff and defendants, they are all sharing the same status. Not with respect to the number of rooms or the locus of the property. Chairs are admitted.
Sir.
One, my lord, one has to be appointed.
Sir, see.
Go and identify.
It is a partition suit. Correct. What the partition court will do first, it is only the preliminary decree. Preliminary decree with regard to the share of the property, share of the
That
person.
has not happened yet.
Not yet happened. Correct. Only the court will decide with regard to the share with regard to the what is the recorded they are entitled for.
Is admitted.
Admitted.
Yes.
Correct. But the not preliminary decree.
No,
Preliminary decree
that's
is
what I
passed.
was I indicate.
So preliminary decree is not passed. With what you wanted to submit before this court, bring from the witness that stage has not come here. Only after the preliminary decree, then the commissioner will be appointed for partition of meets and bonds.
Preliminary
Then the
decree can
partition
be passed by consent. I do not have any objection to that.
let come with the consent. I pass a
Yes.
preliminary decree.
This is what I was indicating on the last occasion. I went through the pleadings. We are not objecting. Defendant is not objecting to the 1/3 share or whatever is the share which is stated in the
Correct.
plain.
That is the in the
Only issue with
partitions.
respect to number of tenants, who is occupying what portion.
So that is
what I was
that cannot, even though you will take the evidence of the witness here, the court cannot decide in the partition suit.
That's why I have not asked anything with respect to share.
Court cannot
I was
pass
on
any
tenancy. It's
order.
a different thing. It's a different with
That
respect
is
to possession.
correct.
That's a different thing.
And who is taking whatever that is with regard to the, you knows better than
Lord,
this
we'll
court.
then take steps. We'll come. We should, in fact.
So if you come, if you are ready, let come. I will pass a preliminary decree and consent decree in terms of 1/3 share of each of the
My lord can
persons.
take that into consideration.
And thereafter, the parties are going to settle the dispute amicably in terms of the partition decree, preliminary decree. It can be partition. If it is not, the commissioner will be appointed and it will be done.
But someone has to scrutinize and see how many numbers of.
So
Because there is a dispute. Because I have seen the pleadings with a lot of paragraphs are there. Plaintiff is saying that there is X number of rooms on ground floor, first floor, whatever. Now there is a demolition which he says. So the number of rooms in Bending Street property itself has reduced. Well, we do not have the record before this court to assist the court into coming to a conclusive finding. So
that finding will when come?
But even at the interlocutory stage, a receiver can be appointed, Millard, who can do the scrutiny. I am not standing in the way. I am inviting my learned friend's consent.
What I propose to do, if you both the parties subject to, if both parties are ready, all parties to the suits are ready, then the preliminary decree can be passed. Correct. Declaring the 1/3 share each of the parties to the suit. If it is admitted, then the 60 days time will be granted. You go and partition amongst all
That
of
is
them.
not partition. I was only inquiring what is the number of tenants and
Correct.
Also
I am telling that I will come to that.
Yes.
Thereafter, if it is done, surely within 60 days, you will not settle the matter. Then the partition commissioner will be appointed. Partition commissioner will come. This is the portion. This portion is coming. This or the lottery, whatever it is. They are the tenant. These are demolition portion. This is the single issue. These are double issue. All the things will come on record, and if it is, then you can challenge. Or if you are accepted on the basis of the final decree can be passed.
There is
That
no
is
scope
the
for
procedure.
challenging preliminary decree on shares, at least.
Share that can be done.
My lord, what happens in this court and when my lord, we go out, something else happens. My lord, it was suggested by him only on the last day that we may settle. My lord, everything my lord, went into stoic silence.
Correct.
We gave a letter after waiting for a week that your counsel submitted in court that you want to settle. Now, my lord, that letter was reverted to that we are into holidays from 26 January, so we can't sit. That is the reply came. Similar, what happens from this court and what happens going out of this court is totally different. If he is serious, his client should be serious on this. Milord, I have no issue. My lord, fix a date. Let it the day and time be fixed.
Because he cannot say he has filed the suit for partition.
Why should I object to
My
this?
statement is that this could have been pointed out quite earlier.
Give
to
the
your
written
lordship.
statement.
Written statement says I am accepting the
written
shares.
statement.
Written statement below of defendants number 1 and 2.
Copy as a copy.
Only two are contesting.
Yes. Only two defendants
Two
are
only. Sister is not here. No. So sister share is not here.
Both have. None of us have said anything about it.
Because those are purchased by deed by both.
Yes, this is a deed.
From the deed, not a
not evolution means.
Okay.
Kindly see paragraph 7 below. Our statement is there.
Yes, come.
We have said we can definitely.
Manually record that.
So they can himself come up and meet my advocate on
Yes,
record. And
give
this
the
can be-
plain though.
Manually record that, Milord. Why should we object to this? The thing is that, Milord, the things which happens in court and things which happens outside the court are totally different.
So there is no denial, my lord, to paragraphs 1 and 4, 1 to 4, even 5 in our written statement.
Shares are admitted.
Yes. That is
That's
all
the
what-
preliminary decree. C will be subsequently. Final degree of
Well, maybe a terms is not necessary.
Hmm.
Your lordship can pass the order.
My lord will pass. Because Milad, the issues are Milad, these are settled because Milad, the deeds are there. Nobody can deny.
And they have been marked as exhibits also. We
Yes,
have not
nobody can
challenged the
deny.
veracity of the deeds.
So Milad, this can be passed. Milad can pass the preliminary decree on this. Registered deeds.
এগুলো তো সব এগুলো তো হয়ে যাবে এই ডিগ্রি গুলো হয়ে যাবে ঠিক আছে তাতে কোনো অসুবিধা নেই। অবশ্যই এটা পরের ইস্যু A to D claims A to A B can be passed, my lord, even at this stage. Now, with respect to commissioner, I leave it to your lordship, my lord, although that is the next course to be adopted.
A and B.
A and B.
A and B.
Yes, my lord can pass that.
তো ওনারশিপটা হোক আগে অত ঠিক আর আর্গুমেন্ট হবে আমরা একটা জায়গায় অন্য হতে পারি কেরেন্ট হতে পারি হঠাৎ তারপরে এগুলো পেতে ইনফরমেশনটা মক্কেলের কোশ্চেনের গা আটকে রয়েছে মাঝখানে কেউ বলতে পারবে যে আমি ওনা আমি চারটে জায়গা নিয়ে আছি না 5টা জায়গা নিয়ে আছি এইটা প্রমাণ হবে আর যদি ক্লেমটা দেখি তার ক্লিয়ার সেটা আমি চাইছি না আমার ডিটেল কমিশনের এখন চাইছি এখানে ফোন মতো
Yes. Mine will pass Milad.
Yes.
A and B.
Yes.
At this moment.
And minor will also, my lord, appreciate that I was the one who took up this point right now.
Where is the proper settled property?
Yes. There are two properties. And both the properties, my lord, the stand is the same.
185 and 186 of the plant. Volume 2.
One 185 is the deed.
No, 180 was schedule.
Schedule, where is the schedule?
185.
185.
Annexure M. Yes, my lord, it's there. That is in my copy.
কোন জাজেস ব্রিফ দিয়েছেন আপনি
No, 185, 186.
প্লেন ও তাই বল ভলিউম 2 অফ দি প্লেন
1 2/3 share. One-third share. Okay.
Benting Street 2/3 and Millard in
Lenin Saroni,
Lenin Saroni
1/3.
1/3. That's all.
So, respectively, even our clients will not also have that.
Where you mention about
Yes,
your share? Paragraph 5.
No, paragraph 7 onwards, my lord. In fact, my lord, in the plaint only it is written.
Yes, 9. Paragraph
Yes.
9.
8.
8, 9,
8 is your. 8 is your.
8 is one.
8 is your.
Yes.
Come on.
9 is different number 1.
Yes, 9 different number
different
1.
number 1.
Yeah, different number 2 is 10.
10 is different number.
Yes.
Those are registered deeds are there.
435.
Would it be your lordship's pleasure that we come back next week with these particulars? Your lordship can, I'm not asking the
My
witness
lord
to
will
come.
pass the order, my lord, and my lord kindly kiss it to be mentioned or for orders any day, my lord pass that order.
I was only trying to assist your lordship with a one page.
No, dorkan nahi.
Whatever.
So appearing for the plaintiff. So appearing for the defendant. Plaintiff witness is present and cross-examination resume. During the cross-examination, it is submitted by the learned counsel for the defendants that the plaintiff has filed the present suit for partition of the suit schedule property, and the parties to the suits are admitted their share in the plaint as well as in the written statement. Counsel for the defendant submit that as the parties have admitted their share, accordingly a preliminary decree can be passed. Learned counsel for the plaintiff submit that the plaintiff has filed the suit for partition, and if the defendants are agreeing for the preliminary decree in terms of prayer A and B, the plaintiff has no objection for passing the preliminary decree by this. Consider the submission made by the counsel for the respective parties. This court find that the plaintiff has filed the present suit praying for partition of the suit schedule property. That is, here record karo, page 85, 185, 186. 185, 186.
Volume.
Italics, बीच में करो. The plaintiff in the plaint has categorically mentioned with regard to the shares of the plaintiff and the defendant at paragraph 8, 9 and 10 of the plaint, which reads as follows. 8, 9 and 10. 8, 9 and 10. Okay. In the written statement, also the defendant has not denied with respect of their share in the property as described by the plaintiff, and as such, this court find that no purpose. This could find that the plaintiff has filed the suit for partition. Prayer A and prayer B of the plaint is with regard to the preliminary decree. As the parties to the suit are ready and willing, are agreed with regard to the share in the property, and thus this court did not find any impediment to pass a preliminary decree as per the admitted share of the parties. Accordingly, preliminary decree in terms of prayer A and preliminary decree in terms of prayer A and B of the schedule A and B property, as mentioned above, is granted. Full stop. The department is directed to draw up a preliminary decree. Within a preliminary decree as early as possible. Yes.
Yes. Deeply obliged, my lord.
Full stop. The cross examination close. Now the court.
Cross examination is, my lord, also with respect to who is occupying what portion, and there is an element of tenancy right.
So see, that can be taken. See, what I am proposing, let it be closed at this stage. After that,
My lord will defer it.
Come.
So then I have to make an application, and those things will take time.
No.
My lord will defer it.
Need not required to examine the plaintiff or the defendant. I am proposing preliminary decree is passed. Correct. Either of the parties come with an application for appointment of commissioner. Let the commissioner will be engineer commissioner will be appointed. He will come and submit the report. And in the report, if you are any problem, then you can recall the witness and examine the witness, or the commissioner will be examined if there is any difficulty. That is the procedure under the partition suit.
Yes, yes. But my lord, I say, my lord, will kindly.
Once the preliminary degree is passed, how the
Examination go on.
how the cross-examination can continue?
Perhaps my learned friend is missing one point over here. There is also, my lord, partition with respect to accounts claimed. Accounts, my lord, is also there because this is a rental property. So
accounts,
according to the
It has to be
plaintiff,
done first.
that's what I am saying. So according to the plaintiff, accounts means the usufructs of the property that has not been equally distributed. That's the plaint case. So they, my lord, at one stage or the other, I need to address this point because I've denied it. I must give a suggestion.
With regard to the that accounts and all these things, the special officer will be appointed. He will examine the
referee will be appointed.
No, not prospective.
Special referee will be
retrospective accounts. That's
I've
the
only
point.
prayed for accounts. For that, special referee will be appointed.
No, retrospective accounts are something, Millard, which a special referee will not.
Or that, Millard, cross-examination cannot go on.
If you wanted to cross-examine, then the preliminary degree cannot be passed.
No, preliminary degree can certainly be passed with respect to Millard share.
No.
Because I have not taken any suggestion.
Then what purpose should be served?
A member of the body is usually appointed for as it goes on before him.
But my cross-examination is not with respect to shares. Shares I'm admitting. Even I am the one who, Millard, pointed this out to the court. That's why I say, with respect to the other aspect of the matter, accounts.
Accounts, so that has to be decided by a special referee.
Where is the prayer of account? Where is the prayer of account?
Then my learned friend's client would, Millard, then undertake.
Where is the prayer of account?
Prayer E.
Prayer E.
Decree passed directing defendant to rendering accounts respect of the rents. Correct. With regard to this is one type of the main profit.
Yes.
This is
being collected by the said defendants. Millard, let it be clarified that they are not asking for any retrospective accounts.
Accounts, Millard, this has to be done by the referee.
Right, but that has to be a starting point. Millard, if your lordship protects me from that, I have no purpose of cross-examination. It has to be clarified.
It has to be referred by. It has to be referred to the referee.
From the date of filing of the suit.
Correct.
From the date, it will come at the date of the filing of the suit.
Millard, the plaintiff says that it is from the date of proceeding of the suit. Special referee will definitely have the jurisdiction to ask for documents from the date of filing.
We'll be providing the documents.
Because he has not asked for any amount.
That I didn't know.
I have not paid for any amount.
That I didn't know.
Not pleaded.
So let that be recorded, Millard. That is what I say.
What is there? That is there.
Lordship will protect
I have not
me to
paid
that
for any.
If you want, herein now I am appointing the special referee to with regard to the accounts and the partition of the.
I agree, Millard.
Anybody
That can be done.
Any experienced person, Millard.
He can take inventory, do the accounts from the date of filing of the suit, and I will have no purpose in cross-examining. I do not wish. I have no purpose in cross-examining.
Correct.
Person is appointed from date of filing of the suit.
Millard, I have not given Millard from the date of passing of the Millard kindly. Millard, I have not quantified any amount.
Yeah, that's I'm telling. There is no amount quantified.
Because I don't know.
There is no amount quantified.
Definitely, Millard, appoint a special officer.
There is no quantified. So
then I presume it has to be from the date of filing. There is no retrospective inquiry. Not for my clients, not even for my learned friend's client. If that is the position, Millard, then
it has to be decided by the referee.
From the
if they are dissatisfied, then my lords comes again.
Starting point. I'm only on the starting point.
What will be the starting point?
Millard, starting point, Millard, they have been collecting rents. That's my.
Correct, but you're not very in which paragraph?
This was an open-ended thing.
Yes.
That's why I was apprehensive.
Where is the paragraph?
Give me a moment. The praying paragraph is paragraph 34.
Rendering account, correct. But see, if the special officer is appointed, so special of one reference point is to be.
Millard, deferring, my lord, Millard. So sorry, Millard. But if it is getting solved, Millard.
Correct. No problem.
Special officer Calcutta court. From date of filing of the suit.
He's saying that he don't want the accounts. My lord, clarify that.
I own the accounts. The witness in the box has said that he is collecting rent from very long time with respect to Benting Street property. He himself alone for the 22 tenants. I certainly want the accounts to resolve disputes.
At his
resolve,
liberty,
I have,
he will pay for this special referee.
no, I have just been.
I mean, my clients are not asking. My lord will record that. He is in court present. He can also depose there.
He will not want accounts because
ask
he
your
will
client.
be in difficulty if he
Ask
gets the
your client.
accounts.
Ask your client.
He is asking
He
me
will.
for
You
the
will be
accounts
paying. I am
of
clarifying
2006.
this.
He's asking me.
I mean, what he's
for
saying
the
that.
accounts of 2006.
What he's saying.
Control
What
the
he's
client.
saying to me very frankly, बेकार का खर्चा होगा छोड़ दीजिए.
Now it is bekar ka kharcha, but when it
This
was
is the
filed, it's not
brothers.
that.
He has trouble. Correct. You tell me. No problem. No problem. See, but that is the trouble, whatever it may be. Correct. Now he wanted to leave all these things, and you will leave. I am passing an order from the date of filing of the what you are collected, that will be decided by the special
I
right.
appreciate.
If you are satisfied, otherwise.
The thing is that he has traveled since what to my father, to my mother.
Please, sir.
That is what.
He has collected rent from 2006.
Correct.
Tax is paid by the state.
No, correct. But after all, you are brothers and family members. After you are the family members. If you are otherwise, the case will continue. There will be no problem.
There has been animosity, but Milord, just by saying I'm abandoning a claim, this is a partition suit. Here claims, Milord.
You will pay. I'm not going to pay for this special referee. Your client is one. My client wants to depose and say that he's abandoning the claim for account. If you want the account, then you will pay for this special referee.
Here, both plaintiff is the defendant and defendant is the plaintiff.
Very well, then you pay.
They're both there.
You are plaintiff.
Your counter claim is there.
No, I don't need because the prayers in the plaint itself is my prayers.
My claim
partition suit.
My client is saying only because of the millet cost.
But then why did he put the prayer?
That lawyers are put in.
I made this submission
if you want
in the last matter.
No, I was hearing to your amazing submission in the last matter. So Millet, if my client doesn't want Millet, he should be not be penalized with the fees. His client want Millet, his client interested, let them pay.
This is not the way, Millet. There is a specific prayer in the plaint.
I'm relinquishing that prayer.
He cannot relinquish it because it is now my prayer as well.
So you pay for it.
The partition suit.
You go on with the prayer. You are welcome, but you pay for it.
That's correct. He's telling if he is not claiming that.
Why should I pay for that?
But he's taking rent for 22 tenants. I have a portion of it.
He is not. If you want, I will appoint the commissioner.
You pay for
on your behalf. He is not claiming that.
Yes, I'm not.
Yes, but then Milord, whatever the remuneration of the special officer would be, the ultimate that amount, Milord, is going to be like an OIT.
With regard to the partition, both the parties have to bear the cost. Partition engineer, I will appoint the engineering commissioner. And with regard to the special referee, I will appoint a senior member of the bar. So he will decide and I will record. He will not claim with regard to the claim, and that referee, whatever this is, it has to
The mandate of the referee, if I may presume, Milord, is going to be to ascertain how many tenants are there, what amount they are paying, and from what time they are paying it to whom. Now, if there is rental income received by both these parties, Milord, both the plaintiffs and defendants, the special referee's remuneration can be borne out of that because they can't claim it to
I'm
be
not
themselves.
pressing on that prayer. Why should I pray?
They can't claim it to be themselves undivided property.
Mr. Banerjee, think otherwise. If he's not claiming and the special referee come to the conclusion that he has received rupees 20 lakhs. You are claiming that he has received rupees 20 lakhs. Then again you have to come with the court
and ask for money from him.
For the money from execution. So then you have to disburse the amount to the special officer. So it is your liability, and whether it has been recovered from him or not, that is a different thing. That is I am telling. If he is not claiming any amount and you are claiming an amount and the special referee come to know, yes, decided, yes, he has received the 10 lakh, 2 lakh, 5 lakh, 20 lakh, whatever it is, then automatically that is to be divided in the 3 parts. 2 parts to 3 parts, whatever it may be. So what you claiming that he has to pay?
If he is interested, he has to pay. He is even if going to the witness box and say that he's relinquished. What can be more done? I'm relinquishing a part of my claim.
That.
Yes, your lordship, then.
So I am not passing, I am fixing a to be mentioned, you
Fine,
take instruction,
I'll take
otherwise
instruction. Only with respect to this.
only this regard to appointment of commissioner.
Yes, yes.
Kindly gives me any day, this week, tomorrow,
I'll take instruction right away.
नॉन कमर्शियल है 30th जनवरी
30th
क्या बोला लास्ट में क्या बोला
30th
फाइनल
Very good.
let the matter
To be mentioned.
appear on 30th January 2025 as to be mentioned only with regard to
This order, this part remains.
this will
Yes,
remain.
this
That-
part may
no, I will finalize subsequently.
Yes, madam, this is remain. What we hear and this remains.
Only with regard to ascertain whether the who will pay the remuneration of the special officer or the commissioner if this court will appoint with regard to the accounts in terms of prayer C.
C.
In terms of prayer E of the plaintiff. 30th, ठीक है ना? फुल स्टॉप हाँ फुल स्टॉप नहीं तो उसको छोड़ दो काट दो हाँ ठीक है हाउ मेनी टाइम आंसर फुल स्टॉप और नीचे और रिकॉर्ड कीजिए लास्ट ऊपर ऑर्डर शीट though this court has passed preliminary decree and as such the evidence of the parties have been closed. Published.